Father, but let me tell you the circumstance and you'll see why I am able to do that. I went into my heart doctor for a stress test, as I do about every couple of years to make sure everything's okay. And he looked at the EKG and said, everything looked great, don't worry about a thing, go home, keep doing what you're doing. And about a week later, he called me and he said, I looked at your EKG again. He said, I see some things that trouble me. Will you come back in? And so I went back in and they did further tests and they found that I had 4 of my vessels that were 80 to 90% blocked. And they put me in immediately for surgery and they found a 5th vessel that was blocked. And so I had 5 bypasses. Little did I know I was a widowmaker just waiting to make Laura a widow. And how often do you have a doctor go back and look at an EKG again after they've already evaluated? I attribute that to so many of you holding me up in prayer all these years and giving me that protection that comes from that prayerful activity. And I want to thank all of you who've done that. I have not worked since last April. I'm finishing up the physical therapy part of the session, and I expect to be back working on a limited basis until I get a little stronger. Probably sometime around the first year I'll be back to full force and effect. But I wanted to thank all of you who have been my clients for so many years. You have blessed my life so much, and it would be impossible for me to tell you how much I appreciate you, how much I've appreciated the opportunity to serve you over the years. One of the good things that came out of this experience is that I found the firm can get along without me. Now, you don't tell them I said that, but it was really gratifying because one of the things that I'm worried about, you know, I've been doing this for 55 years, was that if something happened to me, I wanted to make sure there would be people there to take care of my clients as long as they had need for us as a firm. And you're going to hear from some of the people today who've proven themselves worthy of being trusted in that regard. And so again, thank you all. God bless you for being here. I hope you enjoyed the session. I'm going to turn it back to David. We have a little video he wants to show, and then we'll get the program started.
Okay, thank you.
I'm Lloyd Kopenberger. My philosophy has been that if you serve people, the finances will take care of themselves. Every morning when I get up and I look in the mirror, I say to myself, today you're going to help some people.
I believe in Lloyd's mission. Lloyd's mission from the very beginning was serving families who needed to protect the resources and the relationships that were important to them. We've served over 30,000 families. So when people ask me why I'm here, I truly believe in the future impact that this firm can make.
It's really important when a client comes in that they don't feel like we're trying to just shuttle them out the door, that it's a long-term relationship.
It's estate planning, but it's personal. And we're able to minister to that person and give them counsel and give them guidance and let them know they're not alone.
When we first walked in the door here, we just felt so at ease. They greeted us really in a wonderful, welcoming way.
We just had a much more positive experience than we have had elsewhere.
One of the things that we are known for is the fact that we have always put clients and their needs first. So service is extremely important to us.
As I was getting older, clients were looking at me and saying, hey, your hair's getting gray. I think you're going to retire. And I looked for years for a company that would service clients in the same manner that I felt that I was serving my clients. And I finally found Kopenberger.
I've learned over the years that you do business with people you like and you trust, whether it's the gardener you're hiring or it's your surgeon and certainly an attorney. And what we found when we walked through the door was that pretty much immediately we loved the people here. And that's why we chose Kopenberger.
Without our team of people, we're nothing. We have the best attorneys you can ask for, the greatest education and credentials, but without that team of people, we're not anything.
So not only are you servicing the client, but the fact that everyone cares about each other unites us as one group, and it's pretty exciting to be on a team like this.
The Copenbarger firm is an outstanding firm. They are very generous, they are the most kind people, and they have done an outstanding job for my husband and I.
It was some 20 years ago. We made an appointment and we came to the office, and that's when we met Larry Copenbarger, who was an outstanding man.
We have become a family over the years.
I was really taken by his hospitality, his warmness, and that's how we became friends.
We're keeping that in mind when we're bringing new staff on board, that they recognize that in order of priority, it's serving first. So it's not just about their technical skill, it's really about making sure that they're a good fit culturally, and that's what's ultimately going to lead to a successful transition of Lloyd's legacy.
Someday I'm not going to be here anymore, but the people who have relied on our representation will be. And I know the people that are the clients of Copenbarger will be taken care of in the future just as well by the other attorneys.
I mean, you hear it from our clients. They feel like they're cared for here, and I think to come in and want to change that, I came here because I want to care for them and I want to keep this legacy going.
It gives you a great sense of satisfaction that what you're providing to your client cannot be surpassed. Maybe equaled by some law firms, but definitely not surpassed.
I'm very, very confident in the work that they do here, and my experience has been tremendous.
I believe sincerely when I look at the future possibilities of this firm that we can impact thousands of families just like we have over the last 40 years.
Every night when I go home and I look in that same mirror, I can say to myself, you had an impact in some people's lives today that will make their lives better. Now, how does it get any better than that in life?
How was that?
Got the tech guy up here. All right, and then for those of you who weren't told already, if you need your parking validated, we are going to do that at the end. So hold on to those tickets and don't forget to ask us that before you leave. All right. So good morning, everyone. Thank you for joining us today. We're going to get you guys started. In front of you, you have a handout that goes through all of the slides that you're going to see up here. We strongly recommend you take notes as we go along, especially if anything in here leads to more questions. One of the things we'll mention a few times is that because you're attending this morning, you all get a free consultation. Whether that's an initial consultation, a review, or you just need a meeting to ask a few questions. One of the helpful things is when you bring in these handouts, a lot of times, again, when you flag those questions, we can then address them more directly. So hopefully that is helpful. So I'm going to do a little introduction, especially for those of you who don't know us yet, but also for those who do. Our firm has expanded quite a bit, actually, in this last year with a few new attorneys and faces. So we are one of the largest, if not the largest, estate planning firms in California. That is not only because of the number of attorneys that we have, it is also because of the number of departments. So we have our estate planning department, which is the bread and butter of what we do. That's the heart of what we're looking to make sure everyone is protected under, that you have a plan, that it's going to be well executed, and that your wishes are ultimately carried out. But we also unfortunately know everyone is going to pass away at some point, and there are things that have to happen after everyone passes away. That is where our estate administration team comes in. So after the plan has been set up, somebody has to make sure it is carried out properly. A lot of times the people in your life that are in charge of that, they don't actually want to do every single task that is needed. You'll hear from James towards the end today, and you will very likely see why it can be very helpful to have an attorney involved to take care of a lot of those tasks. We also have a business and tax department. So for those of you who have a rental property, who have tax questions, who have your own business, we can address those things in-house also. And then we absolutely want to make sure as many people as possible can stay out of court. But unfortunately, we know that sometimes it is impossible to keep people from fighting, to keep people from not causing issues that end up winding them up in court. And so we do have our estate litigation department if or when that ever becomes necessary. Now, as attorneys, we could absolutely not do what we do without our amazing staff. So our staff is very much the reason we can help so many people all year long and answer questions, get back to people in a timely manner, and keep the service level as high as it is. Now, you guys are very close to our Orange County office. If you haven't been there already, it's just 2 buildings over that direction, so it's extremely close to this location. But we have locations all over the state. What that can mean is if you move, we very likely still have a location near you. Or if you have family in other parts of the state and they need to come see us for any reason, whether it's for themselves or to help administer if after you pass away they have questions, they can likely find a place for them as well. But we also do a lot on Zoom and the phone now. So if you are not either comfortable meeting in person, it doesn't work to meet in person, you're not in the area, we can do a lot now virtually also. So I briefly mentioned, but we are going to go through quite a bit of information today. So again, take as many notes as you are able. One of the things that we are doing for now the second time is we are live streaming this event. So what that means is this will be on YouTube afterwards for you to rewatch, relook, and do anything necessary with that. If you have family that you want to have watch it, all of this will be there. In addition to that, we also have on our Copenberger website a resource tab. That has a lot of videos that go into specific topics as well in more depth. So if anything today isn't gone into in as much depth as you need, very likely we have a video for you. All right, so let's get you started. So, didn't actually say my name. I am Victoria. I am one of the estate planning attorneys with the Copenberger Law Firm. What I'm going to be covering this morning is why do you need an estate plan and what do you need in that estate plan? So first and foremost, when we are talking about estate planning, we are talking about a comprehensive set of documents. If you ever talk to an attorney and they say, all you need is a trust, all you need is a healthcare, unfortunately, they are going to be missing some sort of protection for you, your assets, and very likely your family. With estate planning, there's a reason each of these documents is necessary, and I'm going to go into the why. Am I back? Okay. All right, so first and foremost, for those of you who don't have an estate plan, this is going to be a great crash course in why. I'm gonna just have to yell. David, I might need my tech guy back. All right, so this will be a good crash course in why you need these documents. For those of you who already have these documents, can you get David, Zach? Oh, there he is. Pause, please. Here comes the tech man. It goes in and out, I don't know. I might have to yell. We're gonna try. Okay, oh no.
Check, check.
There we go. All right, there we go. So, with that being said, for those of you who already have these documents, this will go through why you need to keep them updated, and I'm gonna give you guys a couple of dates to make sure you've done your documents since X date. It's really important once you have an estate plan to understand it has a life cycle, and that life cycle is yours. As your life changes, the documents may need to change as well. So with the healthcare directive, if you are over the age of 18, which it looks like everyone in here is, you need a healthcare directive. As soon as you turned 18, nobody had an automatic right to make your medical decisions. Not your parents, not your children, not your spouse. So what that means is if you're rushed to the hospital and cannot verbally tell the doctor, my husband can make my decisions, legally they are not able to talk to anybody. Legally, they can't even tell your spouse what room of the hospital you are in. Now, some doctors will play with that line a little bit because they want to make sure you have an advocate. But any doctor who has ever been sued under a privacy violation, which every violation is a $250,000 fine, they do not play with that line. So this can then have catastrophic effects if you can't tell the doctor who can take care of you and you have not put it in writing. So your healthcare directive is where you actually decide who is going to make my medical decisions if I no longer can. It's also where you answer some of the end-of-life decisions that come up. This includes organ donation and life support. Answering these questions ahead of time not only ensures that your wishes are going to be carried out, even when you can no longer communicate, it takes a lot of the guilt, frankly, and stress out of the family's hands, because all they need to do is tell the doctor, follow mom or dad's wishes, follow grandma's wishes. That's all you need to say. I had to do this for my grandma, and I can very much say that at the end of her life, when it was time to make that decision of life support, I literally could just point at the document and say, she already made the choice, let her go to heaven. And it's still heartbreaking. It doesn't change the grief component, but it took all of the guilt, all of the questions off my plate. But if you already have a healthcare directive, you need to make sure it was done after 2004. If you have a directive that was done before 2004, it is actually no longer valid. So you could be walking around thinking you have one, and the doctor will not accept it. The reason is in 2004, HIPAA laws changed, so privacy laws changed. And unless your document is compliant with these new laws, they will not accept it. The other thing is it still current? Some people, especially after COVID, we saw the original representatives they had were not who they would still want. And when you are extremely vulnerable, which you are if you can no longer communicate medical decisions, you want to make sure whoever is in charge of that is the correct person, that they still are in your life, that they are still alive, that they still are in a physical location close enough that they can make those decisions, or they're able to be reached on the phone. There's a lot of different reasons that the person you originally named may or may not still be correct. So we recommend for all documents you come in every 3 to 5 years to have these looked at. Not because we expect things are changing every 3 to 5 years, but it's a safe bet that we can catch if things have changed before any event or disaster has occurred. Now the next document that goes hand in hand with that one, that again, if you're over 18 you need, is a durable power of attorney. This is also known as a financial power of attorney. This is there in the event you become incapacitated and can no longer make financial decisions. Now this can be temporarily or permanent. So for some people, and again I'll use my grandma, when she was originally in the ICU, it was temporary that she couldn't pay bills, she couldn't write checks. So the power of attorney allowed me to do that for her. For other people, they have things like Alzheimer's, dementia, they've had a stroke. There's things that permanently keep them from ever being able to regain financial control. This allows the person you have designated to use your money to take care of you. So rather than them having to figure out, how am I going to afford this? Do I have to pay out of pocket? They can use any resource necessary. Now, a lot of people go, well, if it's my spouse, why do I need it? Well, do you have retirement accounts? Those accounts are 100% in your name. They do not have your spouse as a co-signer. Your spouse is only a beneficiary on those accounts, which means legally they can't touch that money until you're gone. Well, that doesn't help if you're alive and that money is needed. So even with spouses, there are certain accounts that even they will need the power under this document to use. The other issue is, what happens if you ever have to have your house sold? You're having to go into assisted living, the house needs to be sold, but you were both on title, you and your spouse. Again, if you can't legally sign documents, your spouse needs the power to sign on your behalf. This, though, is a document that you need to have updated within the last 5 years. If you do not have one that was done in the last 5 years, banks and other institutions are not accepting them anymore. Again, we can thank COVID for that. COVID made a lot of incapacity cases shoot up. The rates went up drastically. And unfortunately, what then banks were seeing is people were using their power of attorney that their parent or whomever had given them, not in the best manner. They were using it for their own gain. So what banks have said is if it's not done in the last 5 years, we're assuming it's out of date. Now this is extremely frustrating when it's a spouse, but you can imagine when it comes to kids and any other layer, it is probably better that they're questioning rather than just saying, yep, you can get to their money with no problem. I actually had a client where she had originally named her son, and in the time, it was about a 15-year period between when she had named him and come in. He had unfortunately, unbeknownst to her, used the power of attorney to take the equity out of her home and used it for himself. She did not realize this. It wasn't until her nephew came into the picture and they started looking at her finances that he went, wait, what is this contract that's sitting here? What is this? And she had no clue. So those are the reasons, unfortunately, that banks, again, are having to crack down. You might love your family, maybe you don't, but unfortunately, in some cases, people can use this for nefarious reasons. So make sure this was updated in the last 5 years. The other issue is if you don't have these documents or they're out of date and unable to be accepted, we then have to go to court and ask for what is called a conservatorship. A conservatorship is basically where they answer the questions that those two documents would have. Who can make medical decisions for you? Who can manage your money? So simply having those two documents that are valid, up to date with the correct people, allows you to avoid this step of court. This, to me, is worse than probate, which if you don't know about probate, we'll cover in just a moment. A conservatorship is a nightmare because what it means is you are incapacitated to the point you can no longer put somebody in place because you can't sign documents, you can't manage your money, you really can't make your own medical decisions, but nobody has the authority to do so. And so we have to go to court and you're sitting there vulnerable. The person is, in most cases, extremely emotionally fried and stressed because you're in a position of vulnerability and now they can't take care of you. So simply having those two documents not only make sure you are covered, it cuts out the court and it cuts out then a huge amount of stress, time, and money that the family ends up burdened with. So the next question we get is, okay, great, I need my powers of attorney, but do I need a will or do I need a trust? Unfortunately, in Hollywood, most people think they need a will because we see in movies people say, we're reading the will, we're opening the will, what was in the will? A will for most of our clients, though, is not enough to fully protect their assets after they pass away. So you are somebody who needs a will if you do not own property. So if you own a piece of property, a will is not enough for you. If you have less than $184,000, a will can potentially then cover you. If you have more than that number, a will is not enough. Now, if you have minor children, you need a will regardless of these other two factors. But it's a different reason. It's because that is where you're naming the guardians of your children. But it doesn't mean you only need a will, again, if you have property or more than that $184,000. The problem is if you do own property or have greater than that dollar figure and all you had was a will, when you pass away, your estate has to go into probate. Here's court again. Everything I emphasize in my section is absolutely making sure you want to avoid court and want your family to avoid court at any cost. The reason is that probate is extremely time-consuming and it is extremely expensive, frankly. Probate is there to answer questions that they said your will did not answer. They need to approve who's going to actually be able to administer everything. So even if you had a will and you said, my child is going to administer for me, they have to approve that. They have to make sure that if you owed any money, that that is paid. So mortgages, car loans, things like that. Did anyone owe you any money? Not as often, but hey, that's a good problem to have if people owe you money. And then ultimately they have to approve and decide where is the money going to go. Now, because this is a legal process that follows their calendar, their rules, a probate can take anywhere from 2 to 5 years after somebody passes away. What that means is it's like picking a scab off a wound. Your loved one dies, and now for 2 to 5 years, you're stuck dealing with the court. You have to keep going to court. You have to keep dealing with the fact, very pragmatically, that someone has passed. It doesn't really allow you to grieve and process because you have to keep going back constantly and over and over and over again. The other issue is, again, it is extremely expensive. Probate costs 5 to 7% of the gross estate. So what that means is if your house's gross value of $1 million, they don't care if your equity is $1 or if you own the whole thing. They're going to put the percentage on the entire million because that is what it could be sold for and that is the percentage they've decided is fair and appropriate. So you can imagine that if your home had a mortgage on it, okay, that's got to be paid. Now you've got to pay this probate fee. Now there's other expenses. Now. It absolutely depletes the estate and keeps it from going where you would have actually wanted it to go. This is just a quick look at how much it can cost. We have on our website, again, copenbarger.com, it's on the different handouts you have. Under that resources tab, there is a probate calculator. If you're curious what probate would cost your estate, go there and get that staggering number and about makes your teeth fall out because it is a high number for pretty much every single person that looks at it. So if you need any further convincing of why for you specifically avoiding court or your family avoiding court is a good idea, take a look at that calculator. The good news, the great news is though, again, you can avoid court. So you avoid conservatorships with those first two documents, you avoid probate, using a living trust. So a trust is there to basically answer all of the questions that the court had said your will didn't. So the trust is there to answer ahead of time. Who's going to administer and manage this when I'm gone? Who's going to make sure my wishes are the ones carried out and that the money gets to the people or person or entities, charities, wherever that I want it to go? It's going to make sure whoever's inheriting inherits correctly. We're going to talk a little bit about the different ways that people can inherit. But if you have maybe not the most responsible child, I have some people in my family, you give them a dime, they spend a whole dollar. There's some people that need advanced protections because of their financial means. If you have anyone who is alcohol or drug dependent, they may not be able to manage it. What if you have a special needs child? Should they just receive their inheritance and then potentially lose out on their government benefits? So you get to, in your trust, determine how they're going to inherit. You also get to decide when. So if you have minor children or you have your grandchildren included, they probably shouldn't get a whole sum of money at 18 or even 21 years old. Most of us were not that mature or wouldn't use it in the best way. So you can decide when people are actually going to inherit, how it's going to be used. So all of that, again, you get to answer ahead of time. You don't have to go to court, they don't have to go to court, and your wishes are the ones carried out. The other thing, though, that a trust allows you to do is you can do quite a bit of tax planning. Now, one of the things we often hear is, I'm not in the 1% uber wealthy. For one, why do I need an estate plan? And two, do I really need to talk about taxes? The answer to both of those questions is yes. Everyone needs an estate plan of some kind, and taxes, unfortunately, affect every one of us, whether we like it or not. Most say not. With tax planning, we're talking about a ton of different taxes, many of which we're going to talk about today. That can be your property taxes. That can be capital gains taxes. For some, it is their income taxes, business taxes. Taxes affect all of us, again, whether we want them to or not. But one of the great things with your trust is in pretty much all cases, we can at a minimum reduce tax liability that's unnecessary, and in a lot of cases completely eliminate it. I don't know any client we've ever talked to that wants to pay the IRS any more than is absolutely required. Most people say the polar opposite. What in the heck can I do to keep the government from getting yet another penny of money they've already taxed during my life? So your trust in your estate plan allows you to preserve and protect that inheritance for whomever or whatever you want. All right, now, I mentioned that you still might need a will, even if you have a trust. So anytime we set up a trust, whether you have minor children or not, you are also going to be getting what is called a pour-over will. The only downside of a trust is that it has to control certain assets to make sure that the assets don't go into court. So generally speaking, when you set up a trust, we have your property put in trust, any real property you own, your checking accounts, savings accounts, and non-retirement investment accounts. Now then the next question I often get is, okay, well can't I just add people as co-signers, beneficiaries, why does it have to go in the trust? The issue with having co-signers is you become liable for them and they become liable for you on that account. You put your kid on, they get in a horrible car accident that's totally their fault. Legally, as a co-signer, they can own that money that you've added them to, and that money then can be taken away in their lawsuit. That's issue one. Naming anyone as beneficiary, that can work. The problem often, though, is there aren't contingencies for those beneficiaries on the accounts. In your trust, we do layers. We say if your child dies, where does it go? Okay, your grandchildren pass away, where does it go? We walk down these layers to, again, make sure it doesn't go to court. With beneficiaries, a lot of times, at most, there's 2 layers. It's spouse or children, children or grandchildren, and that's it. So not only can that be a problem if your beneficiaries pass away, it can also be a problem, again, if anything goes wrong for them. They end up with special needs. They end up on government benefits. They end up in a position where they cannot just outright have money. Your trust allows you, again, to put contingencies in even after you are gone. But the other thing is, making sure it's in the trust doesn't actually happen for a lot of people. We're giving you a ton of information today. We give you a ton of information in the appointments and at the signings, and life is extremely busy. So what often, unfortunately, happens is people walk out at the signing, they remember to do the assets they had at the signing appointment, they remember to go to the bank and get those put in the trust, but 20 years go by, they open a new bank account, they're not even thinking about the trust and they never put it in. So what we do with this pour over will is we say, if, God forbid, you were to pass away and that asset wasn't put in the trust, we have this safety net that tells the court, you still don't get to get your hands on it. Give it back and give it to your trust. That way, again, they don't get to decide what happens. It's that safety net that puts it in. But we do have to go and tell the court, you have this will. So it doesn't fully get rid of their involvement, but it at least mitigates and limits it. Now, the other half of what we talk about outside of your assets, your money, and the practical is the emotional components. And a lot of times that centers around your stuff. So stuff is probably some of the most tumultuous things that we can have. You wouldn't think it would be, but stuff is where we see a lot of fighting. All the time I hear from clients, nobody wants anything, they just tell me to get rid of it. Nobody wants my stuff, donate it, sell it, throw it out. And I will say that is true until you pass away. And all of a sudden, mom or dad has died, they're grieving, and now that thing, that shirt you always wore, that necklace you always wore, that tool that your son learned to use with you, all of a sudden that thing becomes an embodiment of you. And people start to fight, because one of the things Lloyd has actually said is if you think the fights kids had over toys was bad, imagine when they're older and it's over more tangible stuff and you add grief into the mix. It is a recipe for disaster. So one of the things that we have included in our trust is a power that says if you have any personal item and you want it to go to someone specific, either because you know that they want it or you think it will mean something to them, you can use simply a handwritten letter that says what it is, who it goes to, you sign and date it. You don't need a witness or a notary, and you can do these as many times as you want, and if they make you mad, you can tear it up and get rid of it. So it's completely in your control. This also allows you to get vehicles. So your vehicles are included in stuff. So for some people, they want a grandchild to inherit a vehicle. You can even leave that with this letter. The other thing, though, is leave why an item is important. My mom and my grandma are prime examples, and thankfully before my grandma passed, she was able to tell my mom. My grandma always wanted my mom to take this dining room set that my mom really didn't like all that much. She liked her dining set. She wasn't that attached to this thing. She went, I don't want it, Mom. Well, it was like 3 years later, my grandma finally told her, I think it was her great-grandfather had carved the thing in Italy and it had been shipped over. Okay, this kind of weird dining set all of a sudden became a family memento. It had family history, it had family value. And so now it is sitting in my mom's dining area, replaced her table, she got rid of it because it had that meaning to her. So if you have those items, if there are things with emotional value, write it down, record it, put on pictures, who are in the pictures, make sure that that is captured. One of the things we emphasize here is your legacy. And legacy is not just the finances you leave. It is absolutely the emotion, the morals, the religion, whatever it may be, that encompassed who you are, that you want to continue for generations. Okay, with that being said, I am now going to bring Larry up. He is going to cover the first part of the life cycle of estate planning. What may have changed in the law that may trigger you needing to come in for a review and potentially to have your estate updated. All right.
You do a great job there. And some of you who've been a co-partner clients for so many years, you're looking at it and said, how come they keep going over the basics? Well, can you see how these basics are important? And we forget about them over time. Was it John Wooden, the coach of the UCLA? I guess he was the historic winningest coach ever. Is that right? Every year he would take his existing players, he would take the new players in, and he would show them how to put their socks on. He would show them how to tie their shoes. Because he knew that those basic things, if you got them right, it would keep them from being out of the game for a second or a minute or getting injured or getting a blister. That's why we go over these basics. So you know whether you're covered or not. And now I get the pleasure of going over some of the legal updates. And I'm not sure if I'm going to do it now, but maybe after the break. I'm going to go over some other things that are unrelated to anything you see on the picture, but it's personal to you, And this last week, I run into a couple of families where it was important. I'm going to give you a reason not to go off and leave after the break. So I'm going to discuss some things that I think will be important. Now, estate tax, or tax. California, there's an advantage to living here. We do not have an inheritance tax or an estate tax. So you can die in California, and California won't take a piece of your estate, and if you're a beneficiary, they won't take it. So if you're a beneficiary, that's called an inheritance tax. If it's an estate tax, they look at what you have when you die, and they decide whether they take it. The good news is, on the federal level, the estate tax exemption keeps going up, at least for the next year. So in 2024, it's going to go up again. Right now, each of us have a $12.92 million estate tax exemption. How many of us have estates that large? Not many of us. But if your estate's below that threshold, that means you can die and the state of California, the federal government's not going to take any of it. If you're married, you're going to see you can double it. So it means that during your lifetime, I could give away today, if I wanted to, $1.29 million and not have to pay a dime of estate tax if I gave it to you. I won't. But if I gave $1 more than that, I'd have to pay 40 cents on the dollar for the gift. Now I'm going to show you ways you can avoid having that apply when you make a gift, because there are certain exceptions to it. But just be aware that's available. Now, if you're married, you can double that exemption. And there's something called the portability election that could be very powerful. And I'm going to say this for those of you who may have lost a spouse within the last 5 years, and your estate is close to that $12 million threshold. It's not too late to go back and capture your deceased spouse's exemption if you haven't done it. If we've helped you, you've gotten it done. But if you didn't, you can capture up to the full $12.9 million exemption, so that when the Lord calls you home, you'll have that $12.9 million exemption on top of whatever the exemption is when you're gone. You say, well, Larry, what do you mean? Well, in 2025, the exemption is going to drop down from where it's going to be, probably 13 million something, down to 5 million. Potentially, and you may have heard this, potentially that $5 million exemption can have an inflation index to it. But you notice I use the term potentially. In the rules, there's nothing there that says they have to do that. So it may very well drop from 13 million something down to 5 million. So you're happy now because your estate's at $8 million. Well, now it's at 5. What is 40% of $3 million? 1.2 million? Okay. That's how much the federal government's going to get if you don't take action to protect that. And one of the actions you can take is when one spouse dies, talk to us, and we can determine whether you need to exercise the portability election. Again, capturing the exemption amount that remains of the spouse who died first. So, as it says in 2026, they're going to cut the exemption. It says it's going to cut it in half. It's not going to be in half. It's going to go down to 5 million. Now, there is something called the gift tax exemption. So you can give whoever you want, and I'm going to use my wife and I as an example. I can give each and every one of you in this room $17,000. You don't have to declare it as income, and I don't have to file an estate tax return or a gift tax return showing I made the gift. If my wife chose to, and I promise you she won't, and she would keep me from doing it, she could add on to that as well. And if you add the number of people up in this room, it's quite a bit of money. Well, it doesn't eat into that 12.9 million exemption. See a benefit to that? So if you have children, you have grandchildren, you have other people you want to benefit, you can give them that $17,000 every year can't give them a gift, a birthday gift after that. So make sure you keep it at 17. But if you'll do that, you can transfer money and avoid potentially that being taxed at your death. A couple things you need to keep in mind that we often forget about as parents and grandparents. What do you want to do as a parent and as a grandparent? Make sure those grandkids get the best education. Make sure they have the medical expenses covered the way you want them to be covered. What do? You say, okay, grandchild, here's the money. Take it to USC, pay the tuition, get your books, and you're good. What did you just do when you gave that child the $60,000 to pay the tuition and buy the books? You made a taxable gift of everything over the $17,000. How do you avoid that? You pay USC directly. And I'm not a USC fan, by the way. So, those UCLA people in here, you can say he's not. I'm neutral. Unless they're playing Oklahoma, then I'm an Oklahoma. But so if you pay the tuition directly, pay the books, you pay for the room and board, $60,000, you can then give them an additional $17,000 in spending money and not have to file a gift tax return and not reduce your estate tax exemption, that $12.92 million exemption. Does that make sense? Is that clear? So just be cautious when you're wanting to help a child or a grandchild that you use your funds properly and to the most advantageous tax treatment as possible, and that's one way of doing it. Now we're going to get any questions on the estate tax side? Gift tax? So I either did a great job or I lost you entirely. Now the Secure Act. All you need to know about the Secure Act is it's dealing with qualified accounts. 401ks, 403bs, 457s, anything that has a tax-deferred treatment. And the reason it was put into play is so that the federal government could extract at least $15.7 billion from you when you die and you transfer that over to somebody. Now there is an exception. If you give it to a spouse or a child or someone who was within 10 years of your age, they can have the same tax treatment that you would have had. What is the treatment you would have had? Under current law, when you turn 73 years of age, you are required to take minimum distributions. And when you take those distributions, they're taxed. So you pay income tax on them. So spouse, disabled beneficiary, someone within that 10-year window, they can do exactly what you could have done. However, if they're younger than that, or they're not exempt, when you give it to them, they then have a 10-year window to withdraw the funds. And if they fail to exercise that within the 10-year window, there is a 25% excise tax. You know what an excise tax is? It means anything left in the pot, the government's going to take 25% of it. So, which means it gives you an incentive to get it done. However, if you don't get it done, you're giving Uncle Sam a bunch of money. That used to be 50%. So I think last year they changed it. Yes, sir.
Does that pertain to a Roth as well?
Well, Roth's not taxable. Now you still have, there was a rule change on that where you can now, but a Roth is not taxable for income tax purposes anyway.
Right.
I think they were requiring you now.
But there was a 10-year limit, right?
That's right. You still have to withdraw it, but there's no income tax in on it.
All right.
So you can take the whole Roth in the year you receive it, no tax. So yeah, these scoundrels, forgive me. These scoundrels are figuring out all kinds of ways to withdraw money from you. Yes, sir.
What's the R&D? How's the R&D applied in a special needs trust when inheritance is used to fund?
Well, as I said, that's an exception. When you have a disabled beneficiary or someone who is a minor or within that 10-year window, they're treated just like you are. Yes,
sir. The R&D stays the same?
I believe so. I'll have to talk to Sonny on the tax side of that, but I believe it remains the same as what you would have been subject to if we have the IRA go into the special needs trust. And you may not. And most of the time, we try to shift it away if we can. Yes, sir?
Did I hear you say that there's a required withdrawal of 10 years from Roth?
No.
Oh, okay.
No. Yeah, no, the Roth, there's no,
Right.
if you give it to someone, there is some requirement that you take it out of that Roth within a window of time, and I'm not sure what it is. Yes, sir. Or somebody over here?
Mayor.
Oh, yes.
Yeah, what is the minimum distribution you're required to take at 72?
I don't, it's 73 now,
What, 73?
but it's a formula.
Okay, what is the amount you're required, the percentage you're required to take off?
I don't know. It's a formula.
Well, it's a formula.
Yeah, they formulate it based on your age.
Okay.
So the older you are, I suppose, well, once you turn 73, they expect you're gonna live so many years.
You are required to take that?
Yes. Yeah, you have no option on it. The good news is, with the new rules, you can, if you're over the age of 55, you can add additional monies to your IRA, what they call a catch-up. You can pull money at $10,000 out of any 529 educational fund and use that to pay back any student loans. I'm not sure how much good that's going to do, but at least it's some help if you choose to take advantage of it. I already went over the exceptions: spouse, minor child, less than 10 years, disabled, chronically ill. They're not under those same RMD rules. Now Prop 13 and Prop 19. How many of you have heard of Prop 19? Heard anything good about it?
No.
Well, there is some good things about it. And this is the good thing about it. It allows you to move with anywhere within the state of California, buy a home that's of equal or greater value, and carry your property tax to that new home. Now, under the old rules, I think there were 12 counties that allowed inter-county transfers with, between, equal or greater value where you wouldn't have your property reassessed. So there still was some protection under the old rules. Prop 19 made it all of the 58 counties. Is that how many counties we have in the state? Yeah. Quite a few. So that was the good thing about Prop 19. What's the negative? Well, these are the good part. Oh, and you can do it 3 times. That's something to keep in mind. Let me go over with you what you already know and you probably still repeat. And that is, under Prop 13, you could take your personal residence of any value. You could give that to a child, and the child could take it, and it wouldn't be reassessed. So it could be a $10 million home. You could give it to them. They could move to Texas. Keep it as a rental here, no change in property tax. Under Prop 19, they now have a formula for you to determine whether it'll work. First of all, the child can't move to Texas. They have to stay in the state. They have to live in the home. And they have to claim that as their personal residence, what we call the homeowner's exemption. Then they look at, what is your assessed value? You know what the assessed value is? It's what you're paying right now in the property tax. Now this will, if you're paying any attention to the news in recent weeks, you've heard people argue that the assessor determines the value of property. Is that true? No. No, it's not at all. So you bought your property 30 years ago. What's it assessed at? The current fair market value, or what you paid 30 years ago with some incremental increases?
Fair market value.
Well, it's not fair market value. It's what you paid. So if you bought it 30 years ago and you paid $100,000 on the property, you're paying $1,000 a year in taxes back then. And it's going up incrementally, which means you're now probably paying $1,500 a year in property taxes. If you bought it new and you would have paid $1 million for that property, you paid $100,000 now, it's now worth $1 million. What would your property tax be on that? $10,000. But you're only paying $1,500. That's the advantage of Prop 13. What Prop 19 does is they say, okay, great, your assessed value is $100,000. I'm going to keep the math easy. You died, it's going to your child. The child can now add $1 million of value on top of that. So what does that equal? 1.1 million? And not have the property reassessed. So property's worth $1.1 million when you die. Your assessed value is $100,000. That's what the assessor gives it. You add $1 million to that. You give it to your child. They live in the home. That's a requirement. No increase in property taxes. Does that make sense? Okay. If it's 1.2 million, they begin reassessing it. And there's a formula. If your child moves to Texas, it's reassessed. And here's something in terms of, I'll get your question. And here's something in terms of the questions you have to ask yourself. How does my planning deal with that home as it relates to my children? Does it say I want it to be divided equally between them and the proceeds split? That may or may not be a problem. If it's a problem, it means that your attempt to make sure that the kids are treated equally could cause the child who is going to be living in the property and the kids agree, go ahead and take the property, brother. You know, it's your part of the estate. You can buy us out for the difference. Guess what the county is going to do if you haven't put the right language in your planning? They're going to reassess it. Now, it's easy to deal with, though. In your planning, you can put in what we call a right of first refusal. And just say, I'm going to give this one child the right to purchase the property. And if that child can't or is unable, the next one in line. And if they'll exercise that right and live in the home, then they'll get to keep the same property tax you have. But if you don't do that and you have, let's say, 3 children, by way of example, and you're dividing it between those 3 kids, so you have Bob, Mary, and Larry on the property, what are the other 2 going to want? They're going to want the cash, right? Well, by doing it the way you just did it, 2/3 of the property is going to be reassessed. Unless we put in the right of first refusal. Or put something in there so it's clear to the county that that property was intended to go to that child. Now, so it's a good solution to be aware of. And you need to revisit your own planning and make sure, particularly if you have a child that you want to be able to live in the home, that your planning deals with that so that we don't end up having a property tax reassessment when you thought, because you understood the law, that it would, hey, my child's receiving it, there is no reassessment. Unfortunately, you were wrong. Because the law, in fact, even under Prop 13, you could have had that same result with the 3, dividing it among the 3 kids. So without getting into further detail, is that helpful? Yes. And then there was one question back here. I don't want to leave you that. Now I'm going to take a break. Or hand it over to Zach to bring up lifestyle. Yes, ma'am.
Yes, my question is, if you inherit a house and you also have a house, you want to give the house you're living in to your son, what's the consequences?
So you say that one more time?
Okay, if you inherit a house and you can't live in 2 houses at the same time, and you want to give your own house, the one you bought, to your son,
okay,
and you move into the house you're going to inherit, so what are the consequences? Giving the house to your son, the house
you're still living?
Yes.
What she said was, I have 2 properties. I want to have my son have one. Should I move into the other house and have my cake and eat it too? Do you think the county's going to let you do that?
No.
No, because the rule is you have to have the homeowner's exemption on the property that you're going to give to your child. So you may say, I have 3 properties and I want this one property to be my son's, but it's a rental property, it will not qualify for that exemption. It will be reassessed. And see, that's what's going to confuse you as well, because under the old rules, you could have $1 million of exempt value of other property, of assessed value of other property, and not have it reassessed. Prop 19 took that away. So the only property that can not be subject to reassessment is your personal residence. And to be your personal residence, you have to file the homeowner's exemption. Now, I know there's some other questions. I'm going to have to save those until the break. I'm going to introduce you now to Zach from Lifestyle Financial Services. How many of you have met Zach before? You're going to love listening to him. You know, Zach and Charles Sosa are partners in Lifestyle. And if you remember Lifestyle, that was my mother's firm, which is now owned by Zach and Charles.
Good morning, everyone. Happy Saturday. Thank you guys for taking some time out of your morning to come here and listen to all of us. So, my name is Zachary Raymond. You can call me Zach or the guy in the blue suit. There's another one too. Charles is a little under the weather, so I think we can all thank him for not being here this morning. So my name, as I said, Zachary Raymond at Lifestyle Financial. I'm one of the financial advisors there. A little background about Lifestyle Financial. It was founded over 3 decades ago by Laura Kopenbarger, Lloyd's better half. And we have a wonderful relationship with Kopenbarger and Kopenbarger. And as Victoria, who also happens to be my wife, said, everybody here as attendee of this seminar gets a free financial review as well for being an attendee here. So since nobody here knows me, I look forward to seeing everybody. I love making new friends. A little bit about me. I used to work at a small firm called Merrill Lynch. Show of hands. And I have stories. Early last year, I had known Charles Sosa for a while, and we went through the professional dating relationship because as Laura was getting on in her experiences and wanted to stay at home with her grandchildren and great-grandchildren, Charles needed someone who he could trust. Because financial planning and advising at the end of the day starts and is always referred back to trusting the person who I like to say is, inappropriately maybe, touching your money. And you would like to trust these people. So Charles and I spend a considerable amount of time making sure that philosophically and fundamentally we have common core values and a belief in the mission of helping people grow their wealth, maintain their wealth, having a proper plan. I like to tell people we try to plan not just for the next day, week, or month, but for the next 30 years. Because I will still be here in 30 years. I'm a little bit on the younger side. Don't let this hair fool you. And with that being said, I made the decision to leave Merrill, took the clients I was working with. I asked them if they wanted to come with me. They all said yes. And we merged that Lifestyle Financial under one banner to better help people, because 2 minds think better than 1. And so I'm going to walk through the next couple of minutes telling you a few things about what our office does, what our philosophies are, and then I'm going to have right here a few minutes of Q&A, because show of hands who recently has probably spent a little bit more time thinking about their investments this year and last year. It's been a little exciting. I saw some hands raised. That made me happy. So a little bit about Lifestyle Financial. We're a fully inclusive financial planning and advisory office. So we cover everything that you can invest with money, from basic stocks and bonds, comprehensive exchange funds, very fancy vocabulary words in the markets. If it can be invested in, both in real property, commodities, futures, stocks, bonds, we can do it. We can also talk about life insurance, annuities, private investments. Our office is designed to help do the best that we can to bring an educated answer to the questions you might have. And I also very plainly like to talk as if I'm talking to a 5th grade. Not because anybody here never made it to the 6th grade, but because at the 5th grade level, I always say, simple words. You do not want to be confused by people talking about money. We have a lot of fancy jargon. It's the biggest vocabulary word I will probably use today, jargon. I think it starts with a J. Because you want to understand what the investment strategy is. You take heart and feel comfortable with us because we are starting our day very early and doing a lot of the research behind the scenes so that when we communicate about financial planning, financial education, which is very big in our firm, for the financial advising component, it makes a lot of sense to you guys. So these are some more of the services that we go through, and they're boilerplate to cover everything, as I said, about the investment landscape. Very important things, and Larry talked about these, even retirement accounts. We stay up to date not just on the investment side of things, but on the legal side of things and the tax side of things. Larry had mentioned that the current RMD, or required minimum distribution age, is currently 73, but it's going to go up to 75. There's also different rules in place for qualified plans, which you might know as a 401k or a 403b, versus an IRA, or an individual retirement account. So we stay up to date on this because it matters. It matters because, as Larry said, I did not see one raised hand up on who wants to pay more in taxes to the government, both the federal government and the state government, because there's a lot of state taxes here. So a couple of things that our office, again, in a very simple way, tries to communicate. Financial planning and advising is our profession. Many people, and they should be, because we live in the age of information, where show of hands, everybody here has a smartphone of some kind, or almost everybody? iPhone, green bubbles or blue bubbles? We live in the age of information, and so everyone has access to it. I tell Charles every day, I like it a lot when people come with me with questions about stocks or an investment, or did you hear about this financial firm, my old firm Merrill Lynch? It's good to be aware, but then you get overwhelmed by news. We call it analysis paralysis, where you just get so much information, I can't tell what is up, down, left, right, or right in front of my face. And I have very big glasses because I stare at 2 screens in the office. I'm just not wearing them today. So what we do is we focalize and sift through all the noise. This is our job. We take what happens not just in the United States, but around the world. Because what happens in the Middle East, in Asia, in Eastern Europe, it directly impacts the investments in Southern California. Because the world and the investment landscape is smaller and smaller and smaller. So we have to stay up to date on that. That is our job, and we take great pride in staying as up to date as we can. We use a lot of resources at our disposal to have a lot of the objective facts, and we remove a lot of the noise. I tell people a lot of the time you get occupied by big headlines, but they usually come with little profits. So we try to sift not on page 1 of the newspaper, but page 17. I do still read the newspaper. It's a weird thing, but I like it. So the middle point, markets are not fixed and have constant change. That is a very true statement. The markets are constantly in motion. They go up, they go down. They're going around right now because the news, even if the stock market isn't open, is feeding into what will happen on Monday. 6:30 a.m. Western time or Pacific time, 9:30 a.m. East Coast time. So a couple of notes and themes that we like to throw around the office for every people to understand. And I will say that our firm is largely based off of educational finance. Something I actually stole from Merrill Lynch because Merrill Lynch is a good firm, and they do a lot of good things. And I was told by my mentor, who spent 49 years at Merrill before he retired, if you see something good another advisor is doing, steal it. They don't own it. So one of the things that we like to bring around is how to understand the investment cycle. Many people know that the housing market goes through housing cycles, the investing market goes through investment cycles. We are going right now, sometimes when I was at Merrill, I used a phrase called the workout phase, or climbing a wall of worry. These are all ways to try to illustrate or put a picture in mind that the previous investment cycle, let's just say from the great financial crisis, everybody's favorite time in the early 2000s in the markets. If nobody got that joke, I'm so happy for you guys to not get that joke. To, let's say, about 2019. Broadly speaking, it was a time where the markets were going up. There were a lot of things going underneath the surface, but there was a lot of money in the system and very low interest rates. Very broadly speaking, when there's a lot of money that goes into a market and the cost of borrowing money because of interest rates is practically zero, markets go up. It's just very easy for things to have gains. That was the previous investment cycle. Then something happened in 2020 that shifted the board. As we come out of any sort of big event or macro event, you tend to find this new investment cycle start to take roots. The history of investing is older than everybody in this room, and it goes back to the dawn of when people were bartering and trading back before Roman times. Investing has always been around. So the important things to understand, as I tell people, is history doesn't repeat itself, but it tends to rhyme a lot. So when you leave one cycle and go to the next cycle, there's a transitional phase. We like to call it a reset year. What does that mean? Well, a lot of the cores from the previous investment cycle are changing. For example, when my wife and I got our house, we had a 30-year mortgage at around 3%. That is wonderful. Raise the hands who can get a 30-year mortgage right now at 3%. I was hoping I'd make a new best friend right now. Rates change. The cost of borrowing goes up. There's a word, in 2021, I said everybody's, in 2022, unfortunately, everybody's least favorite word, it was inflation. Still around, though not as high in the market's eye as it was, but it impacts investing. Companies no longer can just have these big ideas and little profits. They have to provide value. They have to be profitable. They have to provide a service that people are going to use. So the next investment cycle is not going to be as flashy as the previous investment cycle, but it will be able to grow much more methodically. And so when you see this, you must plan for it. You must plan as it relates to your core plan, the backbone of your investing for the long term, or wherever you are in your investment life. Most people, I'll just tell you, if you're under the age of 70, you are young in the investment landscape. You know, investing is a long sport, like marathon running. If you're at mile 10, out of 26, you haven't even hit the halfway point. So we are planning for a much larger scale. A few of the changes that we've seen right now, and a show of hands who've ever heard this phrase, generational wealth transfer. We are entering into this era. It started a couple years ago, and it's only picking up steam. We're about to see in this country alone over $17 trillion go from one generation to some form of another generation. And it's not just parents to children. It could be current generation to a foundation, parents to grandchildren. Usually, speaking as a very loved grandson, I know that I'm the favorite. But importantly, the investing plans that come associated with this, we've done a lot of research into how to handle retirement accounts to transfer to the next generation, or the importance of college savings accounts. Some of you have probably heard or funded or have been called by your grandkids for 529 plans. Those things are very young in their structure, and we have found them not just as investment vehicles for school, but something that has no cap to invest wealth for generations. It's a very interesting strategy. So part of the financial planning component of what we do is try to pick and choose where appropriate investment strategies. And you can start a 529 with very little because you're growing it for a very long time. So a couple of the quotes that I did steal from other advisors I put up here. The one that is very appropriate is markets do not ring a bell at the bottom. I really wish they did. I'm still looking for the crystal ball in the office. We have a couple of offices and we've lost the crystal ball to tell us when things are happening. We do a good job to understand the wave or the trend. It's important to understand the conditions or the attitudes of the markets. I tell people sometimes that think of the market like an emotional teenager. You ever picture the emotional teenager? They're gonna overcorrect one way or another. I got a new car. I'm really happy. This is the greatest thing ever. I got a C-. I'm not going to be able to go out this weekend. The end of the world is here. The markets function very similar to that. So they're range bound. They swing like a pendulum. And you don't want to try to catch a falling knife at either extreme. What you want to do is have a plan that absorbs, doesn't go down as much when things go down, and is able to capture a fair amount of the upside. We call it a risk return. So we like to practice. You get rewarded for time in the market, not time in the market. Longevity is the most powerful tool of creating wealth and also for maintaining wealth. Everybody usually has some sort of discipline or some sort of feeling, and the job is to put it all in a big perspective and relate to a core plan. And our plans do not just bend because inflation exists or because, and we'll talk about a few of the things for a few moments before I actually want to open up to some questions. There are things on the horizon. There are always things happening in the markets. Namely, and my personal favorite, show of hands, who's ready for the next presidential election? So, politics do impact the markets, unfortunately. and I mean that, unfortunately. It is something that is more sentiment driven. One party is in power, another party is in power, there's a divided government, or as long as there's a Speaker of the House, that helps. Markets have a playbook for all scenarios, because all scenarios have already existed. We just need a little bit of guidance. The rule of thumb is to remove the unknowns from the equation. If you do that, and you reduce the unknowns, you have a better chance at having the prospective outcome. But there are always unknowns. Geopolitical risk. Ukraine, Russia. The Middle East. And then the Cold War 2.0, as I sometimes call it. China, US, and Taiwan. The it's complicated status on a global scale. So we follow all of these big events because, as I had said earlier, the markets are smaller and smaller and smaller. So what happens around the world impacts us in Southern California. And then inflation and interest rates. I'll be the first person to tell you one thing that makes me a little different than other advisors. I tell you exactly what I'm thinking. I think we are likely done raising interest rates, maybe one more hike, best, but we're gonna hold these rates for longer than people think, because although inflation is going down by the metrics that the markets look at, it's stubbornly going down slower and slower and slower. So I'm gonna open up for just one or two questions, but I look forward to seeing you guys in my booth, and I'm happy to make new friends. Yes, sir?
Do you have any advice on some of the banks are turning into a digital currency? Do you have any precautions on that, or what do we do? Do you have any information on it?
Yeah, our sector of financial planning and advising, the question is regarding cryptocurrencies, digital assets. Probably everybody's heard of Bitcoin by now. Look, the future of how value is stored in currency is changing. The thinking on an investment level is looking at who owns the patents behind the technology. Not trying to find, some of you might be covering, there's a big lawsuit going on in New York on FTX and Sam Bankman-Fried. We want to stay away from that. Frankly, the risk return is just not appropriate. But what we look at is who owns the intellectual property, who's got really smart lawyers like Lloyd, who have built contracts to own the intellectual property behind cryptocurrency or blockchain technology. The number 1 and 2 owners are big banks in the United States and small companies like Visa and MasterCard. Because the future of how things are transferred from one to the next, these companies are going to capture that. We just don't know how it's going to really look on the investment landscape. So we're keeping our eyes open. Does that make sense?
What are the precautions?
Oh, precautions? Yeah. Until you can actually take a Bitcoin and exchange it for a cheeseburger at the deli, I would stay away from it. Okay. One more question, and I think I have to go. Yes, sir.
Where's the bottom? Just kidding. Interest rates.
Yes.
Last time there was a banking issue, crisis, high interest rates, the banks had to pay versus the low interest rates that are income. You know, we have a lot of loans out, getting less money coming in, right? Are we looking at a possibility of banking crisis?
Yeah. So the question is banking crisis and solvency. All right, I lied with that jargon word. Another big vocabulary word, solvency. So the way banking works, the short answer, I can give you a longer answer at the break, but the short answer is these big banks, because of the pain and I will say, the kick in the keister that they had to get after 2008, removes a large amount of the solvency problem. Case in point, some people may have heard of Silicon Valley Bank back in March. Our firm wrote a paper on this about March 9th, I believe. That was a lot of noise, fundamentally did almost nothing to the banking system, except First Republic went down, Synchrony Bank in New York went down, Silicon Valley Bank went down. But the banking structure, because of the pain points and the fear leads to action, in my opinion. The structure of the large banks, even some of the small banks, remain very disciplined. It is not an issue. All right. And I am going to give it back to Larry. Thank you guys so much.
Thank you, Zach. And just in he may have mentioned it and I just didn't catch it. If you want to make an appointment to meet with Zach or Charles, appointments are available. And I think they have at his table or at the Copenhagen table. Now it's my pleasure to introduce you to someone you already know, and this is my father, Lloyd. And he's going to
I'm going to introduce a very special person. As most of you who have been part of our family for a number of years know, we don't recommend very many people or give very many people an opportunity to be exposed to you who are our most important people. But the exception to that is a man named Brad Dacus. How many of you know Brad Dacus and Pacific Justice? I'm very strong for Pacific Justice because they protect our constitutional rights. They don't care who you are or what you are. If the government is impinging on your freedom of religion or your freedom of speech, Brad Dacus and his team are there to step in and defend us. And I'm going to tell you, for the first time in my 82 years, I'm concerned about our freedoms. Maybe I'm getting old and paranoid, but I don't think so. And I think every one of us need to be very careful when we sit down and think about who we're going to vote for, who we're going to elect to our government, to make sure that those are people who understand our system and who will make certain that our fundamental rights as citizens are protected from government. Because I think there's a famous saying about when the government is afraid of the people, the citizens are secure. When the people are afraid of the government, they're tyranny. And that is a very real concern. And so without any further delay, let me introduce to you my friend, my compadre, Brad Dacus. Brad.
Appreciate that nice introduction. So, yeah, we started Pacific Justice Institute back in 1997, a good while ago. I know what you're all thinking. How could that be? Because he's so young. Anyway, Gray gives me away. But we started, Attorney General Ed Meese helped us get it going and really helped us make a real impact. We started here in California for a reason, because California is what I call the beaches of Omaha when it comes to the defense of religious freedom and parents' rights and fundamental civil liberties. This is the bullseye. So we started here, and now we have offices all across the United States. We have 7 just in California alone. No one serves California like Pacific Justice Institute. When it comes to religious freedom, parents' rights, and sanctity of life, we do it all across the United States, all without charge, coast to coast, from Miami to Boston, Chicago, Hawaii, everywhere. Houston, we're everywhere. So, yeah, making a real impact. Thank you. So, anyway, it's exciting. We do all our work without charge, which is a real miracle. So, I mean, did you say without charge? The attorney said that? Yeah. But we do it all without charge, and we're real grateful to those of you who are helping make that possible. Also, so I don't forget, on your table are these sign-up sheets. It means a lot to me personally to keep you guys updated with our cases. We have more than 220 cases in active litigation right now, making a real impact. So it's real significant. We'd love to keep you guys updated, and we have great resources to assist you along the way. I used to think that that things were increasing in tyranny, but we were holding back pretty well. And then we got this huge tsunami. It was called the shutting down of churches and synagogues across the country. And then when red states started opening up, some states like California says, no, we actually like people who shut down longer and longer and longer. And it's not like the virus was more dangerous in blue states than red states. I don't think it knows the difference. But anyway, so that's what happened. And so strip bars opened up, pot shops, marijuana dispensaries, all this stuff opened up, but not churches and synagogues. So we went into court, and we filed an aggressive lawsuit, and we lost. And we appealed it to the Ninth Circuit Court of Appeals, and we lost. And then we filed an emergency writ with the U.S. Supreme Court. Now, what's interesting here about emergency writs, they're really difficult. It's less than 1% chance that a regular petition for cert will be taken up by the Supreme Court. That's the traditional route. An emergency writ, that's like throwing a pass from outside the stadium all the way across town to another stadium, and you get the touchdown, okay? It's a mega Hail Mary pass. It's like, well, the Supreme Court took it up, and in just 3 days, and great things happen in 3 days. It'll be Easter for those of you who know. In just 3 days, the Supreme Court took it up, deliberated in their conference room, and they wrote a decision ordering Governor Gavin Newsom to open those churches and synagogues. Then we had, and I thought, okay, this is great. It had ripples effects across the country. It was fantastic. Fantastic. It was a once-in-a-lifetime tsunami. And then I looked, and then another tsunami came. And this was the massive purging of people of faith from their jobs who were doing great work, but they were losing their jobs because of their sincere religious convictions not to take a jab, not to take the controversial COVID-19 vaccine. Now, some people took the vaccine. Some people chose not to take a vaccine. It's not our issue. Our issue is freedom. That's our issue. For people to be reasonably accommodated and not just flippantly fired and not accommodated. So we went and took on those cases, and we've helped save the jobs of not just thousands, but hundreds of thousands across the country. And we're taking on these cases all over the country. In fact, we're suing my favorite city to sue, San Francisco. And we have about 1,000 just in that case alone, that class action lawsuit. And we're taking firemen and police officers and doctors and nurses all across the country, med students. We're even going to bat for people on what I call medical death row. So what's medical death row? I just came up with that term, so that's why you hadn't heard it probably. The medical death row is when someone is critically in need of an organ transplant. And they meet all the criteria. They make the top of the list. And then they're told by about 7% of the hospitals are doing this. They're told, oh, you didn't get the vax? Oh, I'm sorry. Go ahead and die. Yeah. Next. That's happening in 7%. 93%, they go, that's ridiculous. It doesn't actually could be a negative. There's 2 studies showing it actually can help or reject an organ transplant. But the 7% they have contracts with the big pharma, and this is their position. So we've stepped in, and we are winning case after case, saving the lives of people. We also get involved in helping like preschools. There's a preschool in San Diego County, and they were shut down, and their rights terribly violated because, as it turns out, it was discovered that the kids there sang religious songs and learned Bible stories. This is a church preschool. That's what church preschools do, right? On church property. But California has a law that says if you're a certified preschool, and you have to be certified to be preschool, then you can't compel any little child at any time to hear a Bible story or sing religious songs. It is outrageous. And so we filed a lawsuit there to preserve the ability. Now, I remember there was a country that had something like that. It was called, the Soviet Union. That's right, the Soviet Union. But no, not in the United States. So we're taking that on. But then we're going to bat for people with businesses. Like there's a Korean-owned a woman's spa up near Seattle. And it's Christian-owned. They're very conservative. It's a women's spa, Korean spa. You know anything about Korean spas, you don't go there if you're modest. That's why it's just for women, because they don't wear anything. And men's, they don't wear anything. So, it turns out a man comes in. Okay, you already know what's next, right?
No.
Hey, I'm ready to go in there. I assume, no, it's just for women. Oh, okay. I see myself as a woman. I want to go in there. No, just assuming he's being sincere. He has gender identity confusion, dysphoria. Well, he leaves and he files a complaint with the Washington Human Rights Commission. It's like George Orwell's 1984, where they changed the name means actually the opposite of what it is. And they are suing to shut down this Christian-owned Korean spa because they refuse to let a naked man be in the same presence of naked women and their teenage daughters. I don't think this is a debatable, but we live in such confusion in our society today. It is. And you have political forces and legal forces on the other side. We are representing that spa. We are representing every business just like them to stand up to that kind of outrageous tyranny and violation of women and their privacy. In the public schools, we're doing the same thing. We're challenging those school districts, and it's a real problem, particularly here in California, unfortunately, in the locker room issues. Teachers are being forced to, and others use pronouns that violate their conscience. No teacher should ever have to violate their conscience to affirm confusion on any child. Much less when that confusion statistically will mean that child will be, if they keep that confusion, will be dead before the age of 30. Because transgenderism does not resolve depression, and it does not decrease suicide. That's the facts. So we're defending those people not to lose their jobs because of their faith and their convictions. Religious asylum. There's hundreds of thousands, millions pouring across our borders seeking religious asylum. And we at Pacific Justice Institute are not helping them. The reason is because it's bogus, right? It's not really real. We had one case out of El Salvador we took on. And that was a case where he was an evangelist, and he was preaching against the cartel in El Salvador, gutsy guy. And people were repenting from the cartel, they were leaving the cartel, they were coming to Jesus. Cartel says, we got to take this guy out. He's costing us business. So he fled to the U.S., we defended him. But now our focus, though, is on countries defending Christians and Jews who are coming from communist or radical Muslim countries that are persecuting them. That is our focus. And right now we're defending, we actually recently defended about 100 Christian Afghan refugees in a Muslim country, Muslim camp, and we defended them to be able to come to the United States and Canada with a Baptist mission organization to help minister to Muslim Afghan refugees in those communities. And so we're doing that to defend religious freedom for everyone in our country who are being persecuted in some of these intolerant, outrageous, barbaric countries that do not respect religious freedom. We also deal with child protective services, parents losing their kids. Why? Because the parents, we had a case in Orange County. Parents would not, it was discovered, had beliefs that would not affirm confusion for 2 little children that they had. And we had to go into court. We got a psychologist to do a thorough examination to counter this social worker. Otherwise, that couple here in California would have lost their kids because of their Christian religious beliefs. And then finally, the latest challenge we're taking on now is dealing with the scores of Jewish students and Christian students who are pro-Israel in universities across the country, and they're being bullied, harassed, and even physically attacked. They're living in fear on universities all across the country because of their Jewish faith or their support for Israel. And that makes me angry. And when I get angry, I don't just throw something at the TV. No, I sue. So what we do, it's really nice being a lawyer, but so what I'm doing is we're representing, and we did a public proclamation that we will represent any Jewish student or Christian student persecuted for their support of Israel and their beliefs at any campus, anywhere, all without charge. And that's what makes it so exciting with what we've got going on. Once again, these are the sign-up sheets. If you can please fill these out so we keep you guys updated. We're very unique. We don't just cherry pick the high-profile cases. We want to make sure everyone gets any help. And so if you can please fill that out, that'd be great. Finally, let me just say, and then I'll be on the table in the very back outside, so you can deal with me during the break, because I'm going to leave after the break because we have our big gala tonight with Kaylee McEnany at the JW Marriott. So if you during the break talk to me, give these, that'd be great. And we'd love to get that. Let me just make one final statement on this. That's this. I commend you for being here, because the fact you're here means you want to be a good manager of your assets, right? You want to be responsible, particularly for your children. But let me make this really clear. Those assets are not worth much if your children and grandchildren do not have freedom. We at PJI are committed to make sure they have that freedom. God bless you all. Thank you very much.
All right, I'm back. So now we're going to talk a little bit about Access membership. How many people here are Access members? Oh my goodness. All right, perfect. Well, thank you guys for being Access members. This is a membership that we have that Lloyd created, frankly, so that people have more access to us. The Access membership is one of the ways that you can actually help leave a legacy. Not only because with your Access membership, you from an estate planning standpoint get some benefits, but your children or whoever is administering also has a few that they can take advantage of. With the Access membership, again, it's right in the name, it gives our clients who are under that membership more access to us. Our Access members get 2 hours of free attorney time every Access year. So whether they attend this or not, whether they attend an education event or not, they can have 2 hours of our time. So what that can mean is they have a simple question. They can call us and they don't get a bill. Most people don't want to have to call their attorney and potentially get charged. So our Access members don't have to. One of the other huge benefits that I don't think a lot of our Access members take enough advantage of is, especially as we get older, sometimes mobility becomes more limited. With our Access memberships, we will travel to you for no charge. That can be a huge benefit that, again, if you're an Access member and are in need of that, please do take advantage of it. We don't want you restricted in being able to get something updated or get questions answered simply because you can't come to us. We're more than happy to go to you. Our Access members also get $300 off any planning that they do every Access year, and their referrals get to use that $300 credit when they start any planning. So if you have kids or grandkids and you really want them to get their advanced health care started and done, they can have that $300 credit, which knocks a huge amount of then the cost off so that they can also get protected. We have an Access table that is outside. We also have our appointment tables, so we're about to go into our break. If you want more information on the Access membership, or for our Access members, you want a reminder of all the different benefits you have, please stop by because we do have a handout for that. Again, with Access, it definitely ties into legacy. Legacy looks like a lot of different things to every person we talk to, and this is just one of the ways that our clients are able to help capture that. Again, we're gonna now get ready for our break. So we have a 15-minute break. I'm gonna bring us back at, we'll do 10:45, give you a few extra minutes to sign up for those appointments. The appointment table for Kopenbarger is back where you guys checked in. The lifestyle and Access tables are just right across from the doors. If you have any questions, the attorneys will be around to answer them. And then we'll see you guys back here at 10:45.
So we'll start like in 2 minutes. Starting in about 2 minutes. 2-minute warning.
let's go ahead and get started. I know there are a few of you who are still outside. Of course, that's not you because you're here. We're going to do a little giveaway of some little things that the firm has. There's a rule, though. You have to be in it to win it. So you have to be here, in other words. So if you know somebody and you can answer the question that we're going to be asking, they still don't know. So, now, the first question is, who drove the furthest to get here today? Who drove over 50 miles? Anybody? Oh, Idaho. Idaho. Now, wait, Dave. Did you drive or did you fly? I flew. Oh, okay. I guess that's, no, it's the distance. I would have just said drive.
Where in Idaho?
Yeah, where in Idaho are you from?
Just outside of Boise.
Okay.
Nice.
All right. How many Californians have surrounded you?
Too many.
They're all over California.
Yeah. Well, I tell you, that's one thing I've seen is we have clients all over the country. And in Tennessee, outside of Nashville, outside of Boise and other parts of Idaho, Californians are just flocking to it. Colorado. Not so much Colorado, but there are quite a few.
Denver.
Yeah, Denver
is a suburb of LA.
Yeah, it's becoming. And then the next question is, whose birthday is closest to today's date? Yes, ma'am.
10/10.
10/10?
10/19.
10/19? Okay.
November 1st.
November 1st.
Yesterday.
Oh. Anybody closer than yesterday? Well, has this session been helpful so far?
Yes.
Yeah, our intent is to bring value to you, so that when you come here, you actually learn something. Much of the time, you don't remember it, but we're refreshing your memory. Because obviously, this is an area we live in. You don't, and you shouldn't live in it. And that's why you have us, is to help remind you and help guide you so that you don't make any improper mistakes because of lack of knowledge. So anyway, this has been a really great time together today. Lloyd and I can't call you Lloyd, Dad. Dad and I are going to step in and we're going to cover what the next section of the life updates. But before I do that, I want to bring up something that I talked about in the beginning. I was intended to be a holdover. What's he going to talk about? I've been running into families here recently with more than I've ever seen, where there's been issues of, how do you call it, lack of forgiveness, a lot of conflict, not that is manifest in terms of lawsuits or those type of things, but where a mother will come in, a son will come in, and there's just real bitterness against somebody. Now, as you know, we come from a Christian perspective, and we don't apologize for it. One thing I've learned over the years is that when we forgive, the forgiveness is not for the other person, it's for us. And I'm going to strongly urge you, all of you in this room, that if you have any offense with anybody, that you take the steps to begin the process of healing. And the first aspect is to forgive them. And I know that's not easy, but I know from a biblical standpoint, God says to do it. Which means if he says to do it, he'll give you the ability to do it. Now, that doesn't mean you need to be foolish. What do I mean by that? If someone is harming you, they're putting you in jeopardy, you don't need to put yourself back in that circumstance, but you still forgive. So does that make sense?
Yes.
And again, I just see too much pain and too many issues. You want to say something?
Yeah. One of the things that I've experienced many times over my career is when it's time for someone to leave this life, the people who have left things unresolved want to come back and get it resolved. And way too many times I've had to say to that person, you're no longer going to be able to resolve it in this life. You better make sure that things are such that you'll be able to make sure that it's resolved before you go into the next life. And so this thing that Larry's talking about forgiveness, I didn't know he was even going to bring it up.
I didn't know.
But it is critical. It really is. And if nothing else, it frees us, the people. I tell you, many, many years ago, a man wronged me terribly. And I thought it would destroy me professionally and personally. And many of you were clients at that time. And I told my wife when I got up and saw the Los Angeles Times Sunday edition with this story about me, I said, honey, we're not going to have any clients before the day's out, because if I was working with an attorney and that was said about him, I wouldn't take the chance of leaving you and Larry and Gwen in a position where you would be subject to that. Amazingly enough, only 7 people asked for their files. And of those 7, 5 came back and asked to be clients later. But I did something I'll never do again. I said, God, you know what he did. You said vengeance is yours. You would repay, and I'm giving it to you to take care of. I'll never pray that again. Because what happened to that man, I would not have done myself. And so we're dealing with powerful forces within ourselves when we're talking about hurt, when we're talking about grievance. And these are the kinds of things that will hurt you more than they hurt the person that has hurt you. So anyway, I didn't mean to get into all that, but hopefully.
No, that's good. And I want to add one more thing to it. That forgiveness really will help you. I've had a number of clients, but one story stands out where a man who was molested when he was 8 years old. He didn't remember it, but it messed his life up, and he lived in fear from the time of his age of 8 until the time he was in his 60s when this was resolved. God showed him what happened. He knew to forgive the person. The moment he forgave that man for what he did, the fear went away. Now, the man I'm talking about who forgave, he was tremendously wealthy. I think he had $30 or $40 million estate, if I recall. I say that only to put in perspective. You can still be successful and have wealth even when you're wounded. But he was living in fear even though he had everything. So, and enough of that. But what we just talked about is critical. So, thank you for listening. We're going to start off then. Has your life changed? Have circumstances changed? Are the people you named to make medical and financial decisions in the past, are they still the right people? How about your beneficiaries? Do we need to do something different? Has their circumstance changed? Were they capable and competent at one time and now they're disabled? Or have you run into the unfortunate circumstance of you discovered who someone actually is? You know what I'm talking about?
Yes.
You know, where you thought they were one thing, and then suddenly circumstances came about where you were able to find out they weren't that.
Mm-hmm.
When the rubber met the road and you needed something, they weren't there. So you need to modify your planning based on that. I mean, this is life. I mean, and that's what I want you to look at. And of course, how's your health? You know, that'll tell you. He was a widowmaker. He had widowmaker. You know, he didn't know it. I mean, if you look at Dad, he has more energy even now after going through that procedure than I do. And I feel like I'm in my 30s. No, I'm not, but I feel like I am. And, you know, so he can go, he's the Energizer Bunny. But life can change in an instant. So look at your health. Did I do that or did you do that? Okay. I know. So make sure if you have people in your life who are over the age of 18, make sure they get the advance directive in place. Victoria talked about it.
How many of you are Access members? What does it cost you to send a grandchild in when they're 18 and get a power of attorney for health care done for them?
Well, $50.
Is that what we need to correct that? Okay. Anyway, that's one of the best things you can do for a grandchild or a child or a great-grandchild. These 3 young men you've been seeing running around here today, Bradley and Preston and Are you here in the room? Well, those are my grandsons. And, and they're going to be 18 in January, and you can bet everything you've got in your pocket that they will have advanced health care directives right after their 18th birthday.
Yeah, I can tell you that's true because he made me and my wife do it after our first child was born. We had to get our own planning in place. So the next thing we want to talk about is really where the rubber meets the road in terms of your own circumstance. How many of you are married? Okay. How many are not or are married but you're not raising your hand? I'm just kidding. So we need to look in your circumstance. What happens if one of you pass away? I'm going to go throw you off just a little bit. You know there's a benefit to dying other than going to heaven? And in California, it's doubly so. If you're married, when one spouse dies, there's what's called a full step-up in basis for capital gain purposes on the first death if you have the assets you hold held as community property. So all of those properties that you've held for 30 or 40 years, when the first spouse dies, and don't kill your spouse off for this reason, you can then sell the property, no tax.
State or federal.
State or federal. However, what's the issue? The issue is what's the spouse going to do next? How many of you know there's a difference between men and women? Despite what they try to say. We are different. What is that difference? You women know it inherently. It's how we look at our new spouse if we remarry. When you women remarry, what's your main focus? You love your new honey, but your children are the priority. When we men remarry, what's our focus? We love our kids, but our wife is our primary focus. Which means what? There's now a great possibility that those monies that you spent 30, 40, 50, 55, 60, 65 years accumulating during the course of your marriage may now go where?
To that new wife.
To that new honey. We jokingly call them gigolos and floozies. Come along. So that's something you need to keep in mind. Do you need to do something in your planning to deal with that? You know, build it up so that when one spouse dies, do we want to keep the surviving spouse from giving it to that new spouse? All or part of it. That's something you can do.
It doesn't mean that you have to disinherit a second spouse in order to accomplish that. It just means you can protect the children at the same time you're protecting the other person that is now part of your life.
Yeah, so you can do it all. You can cover it, but you need to take action to do it, because if you don't, what do we normally say? If I die, I want it to go to my wife. My wife dies, she can give it to whoever she wants. Probably okay. But is there still a possibility, even with you women, that it might end up going outside of your kids?
No possibility.
No.
I've done this for 55 years. I've never seen it happen but one time. And that was a situation the kids were so bad she would have given it to her dogs.
In saying that, I actually had two circumstances where the mother, I told her not to give it to the kids. They were the children that belonged to her husband who had died. She said, no, I made the agreement that I would give it to them, and she gave it to them. Even though I was telling her she's nuts because they were on drugs, they had all these other issues. No, he wanted to go to them, and they were on drugs at the time before, so everybody knew who they were. Wow. So, anyways, just something for you to keep in mind. In your own planning, do you need to put in provisions to deal with that? Many of you have what we call A/B planning. Have any of you been told that you don't need that any longer? Sometimes you'll go to seminars, you'll talk to your CPA, and they'll say, your estate's so small, you know, it's $5 million, it's $3 million, it's $2 million. You don't need to have the $500,000. You don't need the A/B planning. Well, what Dad and I were just discussing with you was dealing with A/B planning, where you're trying to keep a new spouse or a spouse from giving things away when you die, giving half the estate away.
But it's more than that. It's also setting up a situation where if the surviving spouse gets sued, they're in an auto accident or some other circumstance, in our society you can lose thousands of dollars, hundreds of thousands of dollars, millions of dollars in an accident, and you can end up with that surviving spouse totally destitute. But the AB trust protects half of the estate from anybody ever taking it away from that surviving spouse.
And that's a good point. What we just discussed had nothing to do with tax. Remarriage has nothing to do with tax. Creditor protection has nothing to do with tax, but we're using tax law to gain those benefits. And that's where you want to keep that AB, or at least consider keeping the AB planning for that reason. Or if you don't have AB planning and you have these issues and you're concerned about the remarriage circumstance or you're concerned about a creditor, you may want to add AB planning, even though your estate's small enough that we don't have estate tax issues. Now we're going to deal with the same issue with your kids. How many of you know who your children are married to? Are they in-laws or outlaws? And if you don't know who they're going to marry to, do you know whether they're going to be in-laws or outlaws? Of course you don't. But it doesn't matter. Let's say they're the greatest son-in-law or the greatest daughter-in-law you could have ever asked for. What happens if your child survives you, but doesn't survive their spouse? If you give them the money, and then your child passes away, who's going to get that inheritance? Probably their spouse. I heard somebody say kids. Well, that's only if your planning provided that. But once your child receives the money, does your planning have any say over that? What do you think? So I die, we have 5 children, we gift wrap it over to each of the 5 kids. Does my planning have any say over how that money is to be distributed? No, because I've already distributed it. It's already been given to the kids. So if Laurel's my oldest daughter, she's the one she's going to be number 1 in her class out of law school, graduating pretty soon. So we give it to her, she dies. Judy and I pass away, it goes to Laurel, she receives it, then she passes. It all goes to Chris. Now we love Chris, he's an incredible man. But is there now a possibility that he's going to remarry? Knowing what we know about men, the answer is yes. You women know better. I shouldn't say it that way. You don't need us. We need you, but you don't need us.
Yes.
But the idea is we can set it up so that what we're giving, so we can go to Chris and benefit him, but it can't go to his new spouse.
And that's an important thing, because if you listen to what we're saying, it almost sounds like we're hostile to spouses. I've been married to the same wonderful lady for over 64 years. Larry has a long marriage history himself,
38 years.
But the issue is, you can protect your spouse when you're no longer around to protect them, and make sure that there are financial resources that will be there for them as long as they live and have needs. And you can provide that it goes to your children, so it will be there for them as long as they live and as long as they have need. And nobody can take it away from them. Now, this is not insignificant planning. This is planning that has real benefits when you're dealing in the world we live in today. And these are the kind of things that if you haven't already done it with our firm, you need to come in and sit down and talk to us, and you decide whether this is something that would be appropriate for you or not. These are not things that will be right for everybody, but we want to make sure that you understand that you have these protections available, and you can decide how to use them, so that what I leave to Larry is protected for Larry and his family as long as he lives. If he dies also, it's protected for his widow and her children, and right on down the line, and anybody that they're in relationship and marriage with is also protected as well. So we're not hostile to spouses, we're hostile to predators. And predators can come in all different shapes and sizes. And good estate planning is keeping the wolves outside the sheep shed.
So to simplify what we just said, you can do things for your children that they can't do for themselves. And it falls into 4 categories. You can create it so that they can be protected from a divorcing spouse, so that the inheritance money you're giving them will never be part of that divorce settlement. It can be protected from that child's creditor. It can be protected from a circumstance that I was describing with Laurel where she predeceased her husband. I call that remarriage protection. And then if you have a child who happens to be independently successful, this same planning can create tax benefits for your children so that the inheritance money will not be included in their estate for federal estate tax purposes. So in other words, 40% of the monies you're giving to your children won't be going to Uncle Sam. Again, assuming, when your child dies, assuming 40% holds. I mean, if you've been listening to these scoundrels, they've been talking 50, 60, some of them up to 90% they're wanting the estate tax to be. So anyway, does that make sense? Yeah. So just keep in mind that is available. One of the biggest issues you run into is long-term care. We're not going to spend a lot of time on it, but the focus is make sure you take care of yourself, eat right, exercise, talk to us about the planning that needs to be done to accomplish what you're needing to do. In the past, you've heard stories, many of you heard stories about Medi-Cal that you don't qualify. I talked with somebody this last week where they had been taking care of a mother-in-law, and they had been told that as long as she had a home and a bank account that she wouldn't have qualified for Medi-Cal. She would have. You know, I call it, when you hear of these things, I call it legal pornography, where they're reading stuff on the internet that's not accurate, and they believe it to be true. And that kept them from preserving and saving that entire estate. It could have been saved if they'd have talked to us beforehand.
We're entering a very dangerous time, in my opinion. California has liberalized its Medi-Cal rules so that probably after the first of the year, everybody will be able to qualify for Medi-Cal unless they have a very high income. My concern is that the state of California is not going to be able to withstand that economic drain. And if that happens, we may see a situation where what looked like a very good protection for us will suddenly disappear, and we'll be faced with some real issues. So we're going to stay on top of that for you. We've been doing Medi-Cal planning since about 2010, and we protected, actually, you're right, it's actually before that, but we protected literally probably $100 billion for people with that kind of planning, but it doesn't look like it's going to be needed much after the first of the year. So we're not pursuing that, but we are going to keep an eye on it to make sure our clients are protected to the best of our ability.
But it does need to make sure that you need to make sure your finances are in order, because if you end up going into skilled nursing, here are some of the numbers, and these are actually low. In fact, I heard somebody say, yep. We're seeing nursing home expenses $15,000 plus for skilled nursing a month, and then assisted living, and it goes up. It's insane, but that's what we're dealing with. Medicare, Medicaid. Just remember, Medicare is for health insurance. Medicaid is what deals with the long-term care side, and because that's in flux, we really can't give you a good alternative at this point. As Dad said, California is eliminating your asset limit. So you could have a $5 billion estate and no income and still qualify for Medi-Cal. How you could have a $5 billion estate and not have any income, I don't know, but we could probably figure out a way to that. And then just, so make sure to look and see if long-term care insurance might be viable, what assets you have. You may be self-insured. But we can talk to you about that. You can talk with Zach about it as well. And really that's, I don't want to bore you with the rest of this. The numbers and the rules don't mean anything at this point. I think we're now, did you want to say anything else?
No, I'm about to run out of gas.
Okay, I am too. So now I'm going to turn the program over to Sonny Boren. Sonny is the CPA in our office who also has an advanced tax degree, and she deals with the business planning and some of the tax preparation planning in our office. And I'm happy to turn it over, Sonny, to you.
Thank you very much. You did a great job. How about that spiel on forgiveness? That was so good. Yeah. Come to Copenhagen. We're all committed Christians working for you. Okay, so I lead the business and tax department, and I'm going to tell you a bit. I can do advice on taxes, any really tax issue outside of international treaty work, I can help you with. So if you have issues on property tax reassessment, income tax, estate tax, gift tax, those are the main ones. I love to do a little assistance or a lot of assistance with big fancy Excel spreadsheets if needed. So the business planning advice takes up more of my time though. So that generally starts with an entity question. And that analysis generally has been leading these last years to a realization that limited liability companies are very, very good. They're very popular also, which is another indicia of their usefulness. So you can do more complex things, but why do it if you've got great protection there? So that's what I say here at the bottom, that they tend to have the ideal balance between simplicity and protection for you. But let's talk about why these were potentially relevant. If you have an operating business, or one of your kids perhaps is starting an operating business that's getting successful, an LLC is a great place to put it. Then you can have it taxed in various different ways, one of them being an S-Corp or sub-chapter S-Corporation. So you can go all complex at the tax level to the extent that it's beneficial to you. So, so that's one option. The other is rental real estate that so many people have these days in California. And it really needs to be in an LLC, in my opinion, but we'll talk more. What an LLC does is shield all of your other assets from claims arising from that business or property. If you have this entity well maintained, this is going to be the ticket for you for a very low cost in comparison to a major slip and fall, which can be for a broken back can be huge. And what is shielded, the nest egg, is all of your assets, other assets, your accounts, including retirement accounts, your home, all your other properties. The risk is retained in that LLC box. Insurance salesmen say, insurance will decrease your risk, but I say, why take on any risk at all? Get it all put into this one little place, so your other assets are safe. The risk is real. Many lawsuits have been filed and won against non-LLC landlords, and the courts actually in California are getting so aggressive to protect the little guy, the perceived little guy of the tenant, and to share your deep pockets with the little guy. Even very outrageous results have occurred. This last bullet is about a case where a tenant's dog broke out, ran a couple blocks, and bit someone terribly, and the landlord was held liable. So there really wasn't the legal, casual path for the landlord to be liable, but nevertheless they were. So there's a Prop 19 workaround that can be done with a limited liability company also. So let's talk about what Prop 19 means. If you're going to have a hard time gifting property during life or upon your passing to your kids without getting it reassessed up to current market value for the property taxation. Does anybody not understand that? Should I go deeper? You guys have learned well over the years. Good job. So the bottom line of it is that you'd want to talk to us first so we can counsel you and you can decide what you want to do. So just word to the wise, if you're going to buy a new rental property, get an appointment with me. It's free to start. I'm going to talk about that when you come in. Other entities that we form are partnerships, subchapter S corporations, and C corporations. All have some downsides that are stated here. Corporations are not a good choice for real property ownership generally, unless there's very compelling other reasons to have a regular C corporation and get that double taxation also. Consulting work might be a place where some of you are interested in getting that protected in case there could be claims arising out of your work. Pop it in an LLC, you can save 15% in employment taxes. So this is the little recap on limited liability companies. I've got a sinus infection, so excuse the tea drinking. As I've been harping, a landlord with rental property, an operating business that wants to avoid some of the annual minutes, and I cry out that you not try to do it yourself. People who come in incur a lot more expense getting it corrected and probably have already got some accrued tax liability for things they just didn't know about that weren't obvious.
You avoid minutes.
Yeah, and then the people who don't have to do them harking way back 10 years ago or something, and it's a big hassle. So, our department does all kinds of contracts. Buy-sell agreements are a particularly important one for those of you who have an existing entity and know that someone might leave even during life or upon death to provide for a smooth transition, often with life insurance. So I highly recommend those. Purchase and sale agreements, leases of all kinds. I've got a former life in leasing. And almost unlimited custom crafted contracts. I have to read that because it's a tongue twister. So, to improve your tax returns, if you're looking for an income tax benefit, a charitable deed trust is a trust that you put your property into, especially if it's in rather high income producing. Then the charity gets all of that income for the term of the trust, perhaps 5 or 10 years, not any longer usually, and then you get the property back. So that's cash income to you, but it's also a great benefit to the charity and a deduction to you. A private foundation is if you want to go all the way in charitable planning. I'm doing a bunch of those these days. So this, along with the charitable remainder trust, is a great place to put a highly appreciated asset that you don't want to pay capital gains tax on when you sell it. So private foundations, if you fit within the mold of the Internal Revenue Code, is a great place for charitably minded people because they can have a lot of control on the charitable mission, the investments, and they get a lot of blessing for continually blessing people. The charitable remainder trust that I talked about is very, very powerful. Bottom line, without a charitable remainder trust, you're going to incur approximately 33% tax on the capital gain of that, on the sale of that asset. Whereas with it, there's no immediate tax. And you get a charitable donation deduction for the value of the property over up to 6 years, but keep the income for life. And that is for the life of the, all the way to the second to die, when the second spouse passes. A few more details. The property goes to the charity only after the second spouse dies. The deduction is limited to a certain percentage of your AGI or gross income. You can deduct up to 30% a year if it's your remainder beneficiary is a public charity. So I believe it's one of the best tools in the tax world. This is a public service announcement. There has been a law passed that is called Corporate Transparency Act. And like Lloyd said, government gets a little more information now. The goal of the act, though, is valid to fight financial crimes like tax evasion and terrorists' financing. However, it casts a wide net. It's for any smaller entity with less than 5 million in annual gross receipts and less than 20 employees. New entities are going to have to file promptly, and here's the bad news. You must name all owners of 25% or more of the ownership interest, and also officers that have significant control over the entity. And what they must file is paperwork showing their social security number. So it's one additional item of information that hasn't been widely available to the government. And possibly, and I think it's likely, that you will have to show a copy of your driver's license with picture. So then they'll even know what you look like. So we just have to pray it's not used for nefarious purposes of over governmental control. So there's big penalties, but frankly, you guys aren't going to be subject to those because you have to have lied. And I don't think you will do that. But know that terrorists are going to be in prison if they do. So closing reminders, I'm always talking about protecting your nest egg with an LLC and buying new property in an LLC to be able to gift eventually. That one is really, really important. And finally, if you don't like capital gains tax, consider a foundation or charitable remainder trust. So thanks for your attention, and I look forward to meeting some of you in an upcoming appointment. I'm going to turn it over to my friend James, who has lots of hand motions these days. He gets very animated. There he is.
Give me the mic. Thank you. I'm very shy. I am. I just kind of like what I'm doing. So, my name is James, Estate Administration. People are dying to have me work on stuff? Okay, so I've been restricted. They told me before I came, I cannot move this way because I'm outside, or I cannot go way over here either. So I'm stuck here. So if this part of the room feels like I'm ignoring them because I'm focused over here, that's why. Administration is things that happen either during lifetime or after a lifetime. All right? It's essentially what happens when your trust or your estate needs to be administered. In other words, when we have to do something. So somebody's either become incapacitated or somebody's passed away. Right? And so that's essentially what we're going to go over. This is a picture of your kids. Okay? No stepkids. Those are your kids. Right? And so here's a question. Any of you here parents? Couple? Okay, any of you here have parents at one time? Only a couple of them. The rest of you are lying. Okay, but when you're kids, if you had a sibling, and if you didn't have a sibling and you fought with yourself, you need more help than we can give you. But if you had siblings, right? Did they fight when they were young? Just a little bit, right? And they fought over what? Just kind of toys and food sometimes. Clothes, right? And so who was the judge? Who was the mediator during those fights? Who broke them up? Yeah, usually mom. Maybe dad, maybe, but generally mom, right? Okay, so now when the kids fight, and if they fight, who breaks them up now? Who moderates now? Still mom. It's still mom. No, it's not spouses, because it's probably, but it's still mom, right? Because the spouse, just to hit on that point, you know, the spouse might be helping, right, stir the pot more, right? And so they may be in your ear saying, well, this, and your sister or brother or this all the time, right? And so the spouses might help stir that, right? So basically, when you pass away, now who's the moderator? Who steps in now? The courts, right? Perhaps, or nobody, right? And so my point is, I have 5 siblings, so there's 6 of us. My parents had 6. And knowing us, right? After my mom passed away 20 some odd years ago, my dad's still living. He's in his 90th year. And he's not the judge. He doesn't do that. He just kind of. But anyway, the way we are with kids is like, let's say the most favorite thing I ever was able to do with my mom was make toast in the morning. Right? I mean, that's the biggest memory I have, is we were just every morning making toast. Right? So now what is the item in that house that is going to remind me of my mom? The toaster.
You're going to fight.
So now, yeah, we're probably going to fight. I'm going to fight over the toaster. Right? And my brother, being my brother, what's he going to take when it's his time to take the personal property? The toaster.
Just to make
right?
you mad.
It doesn't stop. It doesn't stop. Right? It's a process to get from point A to point triple Z. So it's not a short process. It's not A to B. It's a long process. Right? And that process, again, depends on, are we having to do this while someone is alive, or are we having to do this after a lifetime? If you're here last year, I spent a lot of time doing this. I'm not going to spend a lot of time doing this year. I'm going to go over it in a summary form. I'll just give you a heads up. This is where I'm going to spend my time. Okay? On this fun stuff. And then there'll be a couple of other things we wrap up at the end until they get the hook out on me. So, there are 4 disciplines in administration. 4. Right? What does the law require? That's the part we're going over today. What are the tax issues? How do assets transfer? And then the last one is a general one. It's just whatever the administrator does. Right? What is the administrator supposed to do? So law, what are the legal requirements? What are the tax issues? How do assets transfer? And then what does the administrator, trustee, executor, conservator, you know, whatever the title is, what are they supposed to do? Right? So this now, oh, by the way, the administrator, I think those are things that are kind of common knowledge, right? In other words, if my age, if Rachel and I, right? If Rachel and I own a bank account together and it's joint, and I die, right? What does Rachel have to do? Well, what if my social security number was on that account? What does she have to do? She has to remove my social security number, put her name on it, right? She might have to take my name off the account. If we owned a piece of real estate together, right? Rachel and I owned a piece of real estate together and I passed away, right? In other words, there are some things that need to be done, right? She'd want to take, and I don't have to tell her to take my name off the account. She's going to do it anyway, right? As fast as she can, she's going to get my name off that account, right? You know, and it's other things too that I think, you know, it's just kind of common, right? If I owned a car, right, and I had insurance, well, she's going to cancel the insurance on the car. If she's my, let's say she's my administrator, right, my executor, my trustee, or whatever. She's going to cancel the insurance on the car. She's going to transfer the homeowner's insurance into her name. She's going to cancel my Facebook page, my Twitter, all my social media accounts. She's going to cancel all those things. You know, divert my email over to her and stuff like that, so she gets all the notices, right? She's going to do those, and I don't think anybody needs to tell her to do that. She's just going to, she's going to do them. It's just common in my mind. These things aren't so common from a knowledge standpoint. Right? So we own a piece of property together, and it's not in a trust, it's just she and I own a piece of real estate together. Right? I die. What does she got to do? Update the land records, right? She's got to remove my name from the deed. That's what updating the land records. Is there going to be a property tax issue when I die and she gets my piece of property? Right? She's Rachel. Rachel's not spouse, Rachel's not child, Rachel's not mom. She's just Rachel. Rachel and I own a piece of real estate together. Right? Yeah. There could be. There has to be a notification to the county assessor. Because guess what? They want to know if they could reassess the property. Right? They're concerned about that. They want to be in the know. Notify beneficiaries, that depends. Right? Because if it's a matter of, like there's a trust or a probate or something, yeah, there's going to be a requirement to notify some beneficiaries. Even if I become incapacitated, let's say I have a trust and I'm still living, but I become incapacitated, still have to notify the beneficiaries. I'm almost up to my 25,000 words, by the way, for anybody who knows about that. But there's a requirement to notify beneficiaries. Legal. I'm not saying to do it. The law says to do it, right? Update the land records. It's a legal requirement. California Department of Healthcare Services wants to be notified. And I like notifying them for another reason, and that would be the Social Security fraud issue, right? Because you know, that could be a problem with in some instances. And so I want to just make sure that the person who passed away, that the state knows that their Social Security, that they have died and their Social Security number is no longer valid, right? I want to make sure they know that. Lodge the will. Somewhere around 1850 in California, a law was passed that said that if anybody dies with a will, that will has to be sent to the court for safekeeping, right? And it has nothing to do with there's going to be a probate or anything like that. It's just like the court becomes a custodian, right? Well, the lawyer has it. We created the will. No, the lawyer then has to send it to court, right? But it's got to get lodged, and it's just a safekeeping measure. Get a taxpayer identification number. So if I die, when I die, that's probably not a question of if, but when I die, what happens to my Social Security number? Just goes away. It's no longer valid, right? So if I have an estate, if I have a trust, if I have assets that need to be administered after my lifetime, guess what? That estate has to get a tax ID number. That trust, probate, has to get a tax ID number because it's a separate taxpayer, right? Temporarily, but still a separate taxpayer. So you got to get a tax ID number for that trust, that estate. And notifying the IRS and the state taxing authorities, right? So if I pass away and Rachel's my trustee or my executor, and let's say I haven't paid taxes for the last 10 years, and I should have reported and paid taxes. You know, is there going to be a tax deficiency on my estate? Yeah. Who should be notified of that? Rachel, right? She's the executor, she's the administrator. And would she want to know about that before or after she makes distributions to all of you people? Because you're all beneficiaries of my trust, by the way. Right? Yeah, she's wanted to do it before. Right? Because what happens if she does it after? And she finds out that I've owed taxes for 10 years. Well, they're going to say, Rachel, you owe us money. And now Rachel's got to go back after all of you people and say, hey, I need some money back. And you're going to be willing to give it back, right? Every single one of you say, oh yeah, here it is.
So she's responsible for it.
So yeah, well, she's responsible as the administrator, the trustee, the executor, yes.
So then they can't go after her.
Oh no, they'll come after her. And she'll make her go after all of you.
Yeah.
Right? So, okay, got to notify the IRS and the California Franchise Tax Board and anywhere else you've got property that you got to report income to. People out in Idaho. I'm pressed for time. Pressed for time. I'm going to get to the good stuff, and then everybody's going to miss out on that. There is no good stuff. So the court essentially says there's two rules. Two rules. If you're a trustee, if you're an administrator, there's only two rules that you have to comply with. One, let's say the trust. One, you've got to do what the trust says to do. Simple. Do what the trust says to do. Two, you've got to follow the law. Right? What I went over before in this is the law. Got to follow it. Right? Real simple. Number one, duty to administer the trust. What does that mean? Do what the trust says to do. So, if the trust says, this table here, there's 4 people, right? And there are 4 beneficiaries of a trust. And Rachel, right? And I'm going to be the trustee this time, but Rachel, right? Because I like Rachel. She's a friend of mine. Rachel's one of the beneficiaries. I'm the trustee. And it says, and there's a house, there's a piece of real property in the trust, and the trust says distribute everything equally to the 4 of them. And again, I'm the trustee. I can do whatever I want, right? Anything I want.
No.
So I decide, because I like Rachel, that I'm going to let her live in the house. Right? She's been in hard times, right? She has some difficulty. And I'm saying, Rachel, you can live in the house. That's okay, right? Because the trust says distribute equally 4 ways, but I can just let Rachel do whatever I want, right? I'm the trustee. No. No. Because the other 3 of them are going to say, what? Get Rachel out of there, right? We want our share. We want our money. Show me the money, right? That's what you want. Show me the money. So no. So they can then now sue me to say, hey, you're not doing what the trust says to do. Right? Duty of loyalty. Good example is the last one. Who's my loyalty to of these 4 beneficiaries? All 4 of them. But who am I showing favoritism to? Rachel. So, number 3. Deal impartially. In other words, no favoritism. I can't favor anybody. I've got to treat them equally? No, in a like manner. Okay? Because they may not be equal beneficiaries. Right? Let's say Annette. Let's say Annette is a 60% beneficiary and the other 3 share 40%. Right? Well, no, I'm not going to treat them equally. I got to treat them in their like manner. Right? All right, duty to control and preserve property, that's essentially just saying, I got to take control. Duty to make property productive. That's if the trust continues over a period of time. That means I have to have it invested. All right, and then where's that one up there? Diversify. There's one down there at 16048 is to diversify. I can't have everything in one basket, right? I can't have all my, if I'm a trustee, I can't invest that way, just having everything in one, right? I mean, there has to be a good reason, because what happens, right? What happens, again, diversify. What happens if I had all of the stock in Enron? If you guys, anybody here remembers Enron? And it's like, no, they're going to come back. No, they've dropped 60%, but they're going to come back, right? Then again, what can they do? They can sue me. Because the rest of the stock market did what? Right? Went the other way. And who pays for that? The trustee. I want to make Rachel a trustee from now on, and she's going to pay for it all.
Nobody's going to want to be a trustee.
So all right, but there's these requirements. All right? Defend action, enforce claims. That just means the trustee can file lawsuits. Oh, keep it separate and identified. No commingling, right? I can't take my personal assets and put them into the trust, right? I can't do that. I've got to keep the trust assets and my personal assets separated. Delegate. It says you have a duty. The California Probate Code says you have a duty not to delegate to others. In other words, I can't have somebody say, well, here, do some of these trustee responsibilities. I want you to help pay bills and stuff like that. Anybody have a trust prepared by Kopenbarger? Just one or two of you? The rest of you, none? No? You know what your trust with Kopenbarger says? You can delegate. Well, it says you can, but the law says you can't. Well, which one's right? The trust, yeah, Kopenbarger. Why? Well, the law initially says that whatever's written inside your trust supersedes the law. And the law is only there if your trust doesn't specifically address it. Unless what you say in your trust is against the law or against public policy. Right? So against the law would be, Annette gets $1 million if she kills Rachel. That would be against the law. So that would fail. That kind of a distribution. Co-trustees, moving on. Co-trustees. Anybody here have co-trustees? Anyone? Anyone? I hate them. Can't stand them. And there's a little bit of self-interest there because if there's, say, 4 co-trustees or even 2, how many bosses do I have? 2 or more, right? Who likes 2 or more bosses? Right? Because now you're potentially doing 2 different things. This one wants you to go left and that one wants you to go right. Right? I don't like co-trustees. In fact, if there's a co-trustee, I try my hardest to just get one of them to hire me. And I don't want to be the attorney for the others. Why? Because then I have one boss. Right? But think about it this way, from a trustee standpoint. The law says that they're all responsible for everything everybody does. Right? The trustees. If there's 4 trustees, they're all responsible. So if one of them's doing most of the work, all of them are responsible for that work, whether that person is doing it correctly or incorrectly. Right? And so then how does a co-trustee work? How does it really work? It doesn't. It's like Congress. It doesn't work. Right? I've got this co-trustee vehicle, and maybe some of you have heard it before. And it's a fantastic vehicle. It's cush. And it goes fast. It's sleek. It's smooth. It takes turns really well. So the issue is, right? We have 4 trustees. This automobile has 4 steering wheels, 4 gear shifts, 4 accelerators, 4 brake pedals. Now, what we're going to do is we're going to go down to Fashion Island. All right? And how many different ways are there from here to get to Fashion Island? Several. Now, the car's in the parking lot, ready for the 4 trustees to get in and to go down to Fashion Island. How long is it going to take them to get there? This one wants to go left, that one wants to go right, that one wants to go slower, this one wants to go faster. Yeah, they're not going to get out of the parking lot. Unless what happens? Remember, they're all responsible. So if one of them's in an accident, they're all responsible for the accident. So what's going to happen in order to get down to Fashion Island with that car? 3 of them have to raise up their hands and say, "The hell with it, you do it." Right? But they're all responsible. So that's why I don't like co-trustees, because nothing gets done. And the only way it gets done is there's one person who's going to do all the work, and they're going to hate the fact that the other ones were trustees and didn't do a doggone thing. Right? Tell me I'm wrong. You know those co-trustees. Tell me I'm wrong. It's not a matter of, I don't want to hurt their feelings. Because guess what? You're gone, or you're alive, but need an incapacitated. Somebody, the one who's doing all the work, feelings are going to get hurt. And they're not going to like you at that point. So think about it. You're not going to be liked one way or another. So
if you're on it as you have 2 co-trustees, let's say, how do you get rid of one of them?
I can't answer that. We're on screen. But see me afterwards and I'll give you a name. Oh, no. No, you just change your trust. You amend your trust and you say, no, look, rather than the 2 of them, this one, right? Like my mom, for instance. Love my mom, right? She's been now deceased 20 some odd years. She used to say to me, James, I don't mind if you're my trustee, financial legal decisions. I don't want you to make medical decisions for me. And you know why? Tight. She's concerned, right, that I would be making a medical decision based on cost. Well, it costs less to let her go. Just let her go. Right? So it's like, sure, right? Financial, legal, do it. Medical, no, not you. The point is, we're all good at something. And some of us are not good at either of those two, so I don't want them on at all. Okay?
Yeah, but Jim, if you've got.
Can you ask me afterwards?
If I can, yeah.
Yeah.
Okay.
So, co-trustees. Comply with a prudent investor rule, diversify, duty to report information, and duty to account. Those are basically two similar scenarios. Look at the tone. Okay, so if I'm the trustee, you're all beneficiaries, all right? And my dad, it was my dad's trust, you're all beneficiaries in my dad's trust. You all come to the funeral. You see me at the funeral, right? And I say, hey, how you guys doing? Yeah. Now, we're going to administer the estate, right? You haven't heard anything from me, right? Because we're just at the funeral. You went home. We saw each other at the... I'll contact you soon. Tell me when you start getting nervous. A week goes by, you haven't heard anything. You can shout it out when you're nervous. 2 weeks go by. A month go by, I haven't said anything. All right? 3 months have gone by. 6 months. Get nervous, anybody? Oh, by the way, I just got a new car. 8 months go by. Okay? Guess what? You guys aren't thinking happy thoughts, are you? No, you're thinking the worst. Because, you know, how did he buy that new car? Right? He used that money. He used my money to buy that car. Right? That's what's going through your head. It's not like, oh yeah, he's just doing whatever, right? And so got a duty, I've got an obligation to reach out to you, be proactive, and let you know what's going on. Because that's good. It's not going to make you perfectly comfortable, but that's going to give you some level of comfort. Because I know you guys trust me anyway, right? I know that. I'm just a trustworthy person like that, right? But still, there's that little thing, right? It's it's that on your shoulder. Get off my shoulder, right? The little demon over there saying, he's doing something wrong, right? So I have a duty to report information that's financial. Because at the end, right? Remember, you're my dad's beneficiaries. At the end, you haven't heard anything. You don't know how I spent the money. I hand you a check and I say, here's your share. Folks okay with that? I guess not. Right? No. Right? At that time, you're all from Missouri. Show me, right? Show me. Right? So no, okay, so that means I have to create some kind of a financial record of, hey, here's where the assets were when he died. That's an inventory. And here's how we spent the money. Expenses, funeral expenses, James's new car, the boat, right? All of those types of things, right? You want to know. So at the end, you could look at this report to say, hey, okay, look at it. Here's how the money was spent. Here's how the investments were sold. Here's what they got. And now you're like, yeah, okay, that makes sense. Or it doesn't make sense at all. Right? But you want to know. And as the trustee, I have an obligation to show you. Only you can tell me, don't worry about it. Don't worry about it. Because remember, there are basically two main people when it comes to this, and both of them are unreasonable. There's that person that says, James, what are you doing now? And 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 what are you doing now? Right? That's unreasonable. And there's that other person that's going, dude, hey, I don't need to know anything. Just give me the check at the end. Both of them are unreasonable because I have an obligation to show, but it's a reasonable obligation. So I don't have to say, every minute you email me, every 5 minutes I get that email, I don't have to respond to them all. Okay? It's only a reasonable obligation. Account discretionary. After this, I'm going to go faster. Discretionary. And I know I showed that you guys had a show of hands before, but this time again, how many of you have kids? Ooh, a few more. How many of you have parents? Almost everybody. So the rest of you must be clones. All right. All right, so I know none of you have heard this because your parents weren't this way, and I know none of you have said this because you're not this way. But you've heard those parents and those kids, when the parent says to the child, do this, and the child says, why? You've heard the parent say, because I said so. Now, none of you say that, but guess what? That's discretionary power. A trustee can never tell, or an executor can never tell any of the devisees or beneficiaries or heirs, we're doing this because I said so. I'm letting Rachel live in the house because I said so. I'm the trustee. I can do whatever I want. No. No. If I do have discretionary power, it has to be exercised reasonably. And so allowing Rachel, going back to the first story, right, allowing her to live in that house is beyond one, my authority, because it said equally, but it's also unrationally, right? It's not rational. So no, I can't do that. If I have discretionary powers, it has to be exercised reasonably. Oops, I'm going the wrong way. Taxes, you've heard some stuff about taxes. We're going to go through this real quick because guess what? I'm going to slow down next year on taxes. Income tax returns, personal returns. Yeah, I die, my returns, my final return. So I die on May 31st, from January 1 to May 31, that's my taxes. After May 31, the trust. Fiduciary returns are the trust returns. Estate tax, you've heard somebody earlier talk about estate tax, and so that's all I'm going to say about that. Portability, you heard somebody earlier today talk about portability. That's all I'll say about that. Basis, we talked a little bit about that, but essentially for those of you who are a little lost on basis, it's a difference between if I buy something for 100 and I sell it for 300, the government says I have to pay a tax on that 200 increase, right? So the 100, what I purchased it for is the basis. Well, guess what? If I buy something for 100 and I die and it's worth 300, and let's say Rachel's my trustee and she sells it for 300, then there's no tax because there's a new basis. Larry referred to it as a step up in basis. There's no such law as a step up in basis. It's a new basis, higher or lower. The basis changes as of date of death. Property tax, there is no exclusion. That's the way I look at it. It doesn't apply anymore for a real narrow purpose. There is, yeah, if it was my primary residence and if my child takes it as their primary residence and all these other requirements, then yes, there's an exclusion, but other than that, no. How do assets transfer? Depends on how they're owned. If I own it by myself, there's a good chance we're going to go through some kind of a probate procedure. If Rachel and I own something jointly and it's right of survivorship, it's hers, right? Regardless of what my spouse says. Well, she could sue and say, hey, it was community property, but that's another story. We'll get to that in a couple of years. Beneficiary designated property, life insurance policy, right? So it's in my trust, right? I mean, my life insurance policy says, that Linda's the beneficiary of my life insurance policy, but I said my life insurance policy in the trust, it goes to Annette. Annette. Well, which one's right? No, the life insurance policy. Because it's a contract. And I hired them to say, hey, when I die, pay it to Linda. So even though the trust says it goes somewhere else, too bad. It goes to Linda. So who owns it? Who's the beneficiary? Those control. And then the trust, it depends on the trust. There are single person trusts, joint trusts with spouses or other people, AB trust, ABC trust, charitable remainder, charitable leave. To me, a trust is a trust. We just have to do what it says to do. That's all I got. Thank you for listening. I enjoyed your company. Have a good day.
All right, so, this is good.
Is it? Oh, it's not. I thought it was you. Well, I guess, here, my name is now Frederick. I want to introduce myself. My name is Frederick. Who should I refer? I don't care, everybody. It says here, let's read it. Your family, your friends, special interest groups. Anybody here like volunteer somewhere with some group? Send them in. Send them in. Look at, some of you may not like this, but I'm a Kiwanian. Okay? And so, yeah, refer them all in. Refer them all in. Your church, every single one of them, refer them all in. Which means that if you want somebody, if you like what we do and what we've done, and you know we do these seminars, like estate planning seminars, and we can do them for the organizations, the special interest groups, we can do them for the churches. Heck, Victoria will even do it at a block party. You want a block party around your house, invite all your neighbors? I know she'll show up and do it. Anyone, friends, neighbors, family, non-family, hey, we'll even take your enemies. Because guess what? It doesn't say bless your enemies. Yeah. There it does. There you go. So everybody, I look at it this way. And why? Like, why should we refer to you? I look at it this way. And I know the other attorneys in the office do the same thing. I believe that everybody who sits on the other side of that table from me is appointed to be there by God. Not necessarily to be a client. Not necessarily to be a client. But they're appointed to be there by God for some reason. Because I believe God is sovereign over all things. Okay? So, as an example, I had this gentleman sitting across from me one time. He's in his 60s. His son was in his 40s or 30s and died in a motorcycle accident. And he didn't have much. The son didn't have much by way of assets. And, I mean, I'm such a serious guy, the meeting was all completely serious, right? But it wasn't, right? I mean, I'm not. So we had some laughs. After the meeting, he said to me, James, I haven't laughed in 3 months. Who's to say that's not the reason he was supposed to be there? I do not know. All I'm doing is what I'm supposed to do. And I believe everybody else in the firm is the same way. But to me, that's the most important. We're going to do what we believe we're supposed to do. Refer everybody. Refer everybody.
Thank you. All right, so we are at the end of today's seminar. Thank you guys all for being here. Again, if you haven't already taken advantage of the free consultation, please do so. Again, it's all back at that first table you checked in at. For those of you parked in the parking structure, you do need validation. If for some reason you leave without it, we'll have somebody over there to let you out. If you're just in the normal lot, you're free to just drive off. The other thing though, before you drive off, is if you can give us your green sheets. That lets us know how we did today. If there's anything you wish we had done more of, less of, we're doing these for the people who come. And so we want to make sure we're really capturing what you guys are interested in. If you're not ready to sign up for an appointment, you can also mark on that sheet that you would like us to reach out to you. So please feel free to note that as well. Thank you again for being here. We really, really appreciate it. We hope you guys have a great rest of your weekend.